Good morning, folks. It's the Energy and Carbon Management Commission, ECMC. It's Wednesday, June 3rd. It's 9 a.m. Let's do the roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins.
Here,
Mr. Chair, you have five commissioners present.
5 is a quorum. Good morning. Welcome, everybody. We start with commissioner comments, an opportunity for commissioners to apprise the rest of us of activities. Commissioner Messner.
Thank you. I'd like to inform the commission that there'll be a Colorado Produced Water Consortium meeting next week. It's our first in-person meeting of the year on June 11th and 12th. The agenda will include, the meeting will be held in Trinidad, Colorado. On June 11th, we'll do a tour of the Raton Basin and some different produced water discharge areas to give the consortium an opportunity to see some of these sites on the ground. In addition, the mayor of Trinidad has offered a walking tour and a history of Trinidad that we'll be doing on June 11th as well. And then on June 12th will be the primary meeting where we'll talk about a number of different things, but including produced water management on state parklands by Dr. Karen Volchura, who's the statewide energy lead for CPW. Produced water management in the Raton Basin by John Lipka from Evergreen Natural Resources. An update on the Raton Basin study by Rick Allison, who's ECMC's Northeast Area EPS and Groundwater Investigation lead. And then we'll be looking ahead to start to develop some of our work plans for 2026 and 27 as the consortium. The June 12th meeting is open to the public. There's opportunities for public comment to happen at that meeting. It is a hybrid meeting, so you can attend both virtually and in person. And information on the agenda and additional information about the meeting can be found on the Colorado Produced Water Consortium website. So that is my update for today.
Thank you, Commissioner Messner. Questions? All right. All the best with those meetings next week. Glad you got that dialed in. Anybody else? Seeing none, move to consent. We have 4 hearing officer recommendations under Rules 505 and 508. Does anyone have questions on consent? Seeing none, all those in favor of consent signify by saying aye. Aye.
Aye.
Aye.
Any disapproving? Motion carries. All right. Excuse me. We're now going to move to public comment. We have several docketed items this morning. There's a docket 2506-00109, a docket 2512-00262, and a docket 250800172, and a docket 2412-00314. These are all oil and gas development plans. We also have a presentation a little bit later this morning. We have 25 people that have signed up for public comment. We're just going to take all the public comment up front, and your public comment is identified to a particular docket number. Please let us know. We'll take notes and make sure that those notes correlate with the information we're taking on the dockets that are being testified to. We have 2 representatives. They get 5 minutes, and then the general public all gets 3 minutes. We've got a public comment calculator going up on the screen, so that'll show folks how much time they have left. And we first hear from Representative Nikita Ricks.
Apologies, Mr. Chair. We're elevating Representative Ricks. She's appeared under a different name.
Hello. You are indicated to be Abba Feliciano, but you're also muted, so we can't hear you.
Oh, perfect. Sorry. Yes, I just got the button somehow. I actually, Rep Rix has asked me to let you guys know she's kind of in a pickle right now. Is it possible for her to go closer to 9:30?
Yeah. We'll accommodate Rep Rix. So, why don't you raise your hand when Rep Rix is ready, and then we'll recognize her at that point.
Okay. Should I just exit and then rejoin so I'm not a panelist?
Yeah, just rejoin when you're ready to go.
Okay, thank you. Apologies on that.
Okay. Then we have Representative Eliza Hamrick.
Hi, good morning. Can you hear me?
Yes, and we can see you. Good morning.
Oh, great. Thank you for the opportunity to speak today. As Representative Eliza Hamrick, I represent House District 61, covering over 89,000 residents, and I'm testifying to formally request ECMC to reject the application being considered today. I join thousands of my neighbors in reminding you all on the ECMC board that you have clear authority to deny this application and you're under no obligation to approve it. Rule 307 explicitly permits denial when an application poses risks to public health and safety, risks that, as you will hear today, are quite evident in this proposal. The State Blanca West Mega Well Pad is one of the largest proposed residential well pads in Colorado, located less than 1 mile from the nearest homes. This location, in combination with all of the other well pads within the Lowry Ranch Cap, poses an enormous threat to thousands of residents and surrounding communities. Over 10,000 households live within 3 miles, including an estimated 78,000 children and 4,000 seniors. Aurora Reservoir, the city's primary drinking water source, is only 0.6 miles from the proposed site. Drilling is planned next to this critical water supply. The site is also 1 mile from 2 elementary schools and less than 2 miles from a middle and high school. The plan calls for nearly 18 wells on nearly 17 acres of land, and critically will involve 2 site occupations, meaning 2 phases of disruption for residents. The location is unacceptable. Crestone Civitas has secured multiple waivers to bypass the full protection of county rules in order to place the State Blanca West well pad this close to homes and the Aurora Reservoir. Each fracking well requires 20 to 25 million gallons of water, an amount well over the limit of what our city, state, and county can afford during an ongoing drought. This water is permanently destroyed and removed from our future water supply. Crestone is no longer guaranteeing the use of electrical powerful equipment during the 440 days of pre-production, which is also very much of a concern. In 2022, the EPA reclassified the Denver Metro North Front Range from a serious to a severe non-attainment area for air quality. This project will make the problem worse. The American Lung Association has given the Aurora area an F in air quality due to ozone. In May 2025, CU Anschutz researchers published a study showing that Colorado children living within 3 miles of oil and gas activity face a significantly higher risk of developing acute lymphoblastic leukemia, ALL. Current setbacks between well sites and homes are not sufficient to protect children's health. The study shows that not just distance, but also the intensity of the activity and density of well sites around a child's birth residence increases the risk of ALL. Remember, there are 7 more well pads with 151 additional wells within a 5-mile radius. Why is the ECMC willing to put children's health at such a risk? I urge you to heed the words of those you will hear today, those who are most impacted, and please reject this application. I thank you for your time.
Thank you very much, Rep Hamrick, for being with us. We appreciate your taking time out of your day. Okay, we move to general public comment. First is Karen Artel, and then after that is Jason Wu. Ms. Artel, you're muted.
Sorry about that. Hello, Commissioners. My name is Karen Artel. Thank you for the opportunity to comment. Wellington Operating has applied to continue treatment and discharge of produced water into the Box Elder Creek alluvium, a shallow aquifer in Larimer County. The ECMC classifies this facility as a centralized E&P waste management facility. Water testing apparently found elevated radium-226 and 228 levels at a monitoring well in 2025. A radium testing plan was developed and followed by the operator. It looks like the facility was shut down or did not treat and discharge water at various times in 2025 and possibly in 2026. If my memory is correct, testing for PFAS was positive in untreated water before and after the approval of the application in 2021, necessitating improved water treatment with continued PFAS testing, later changed by commissioners to annual testing. I noted an email communication between ECMC staff and the operator, with the operator asking about shutting down the proposed water treatment facility. I emailed the hearing officer and commissioners with questions about general administrative applications and a possible administrative renewal of this application, as noted on the docket, and about documents I could not locate. The hearing officer did respond yesterday. The documents I couldn't find are consolidated under Exhibit 2 map to the application. The hearing officer explained the application has an August 26th hearing date and may be heard by the hearing officer. If so, the item would then be placed on the commissioner's consent agenda, if appropriate. I look back at my comments for the 2021 permit renewal hearing before the commissioners and email communications after the application approval. I was concerned about transparency. The Water Quality Control Division consulted on the application, but there was no written consultation document. My understanding is that not all of the Water Quality Control Division's recommendations were accepted at the time. CDPHE Energy Liaison Tessa Sorensen's recent presentation to commissioners noted that all CDPHE consultations are now provided in written form. Considering the issues that have occurred with this produced water treatment facility over the past 5 years, will the Water Quality Control Division be consulted and provide a written consultation on this renewal application? Thank you for your consideration.
Thank you very much. And we did receive your written testimony as well. Mr. Wu?
Hi, can you hear me?
Yes, and we can see you.
Okay, great. So I'll get right to it. First, I think we can all agree that the government, our democratic government, is to work on behalf of the people. Now, because there's so much distance between us, the electoral process, and the legislative process, commissions like the ECMC exist to account for and adjust to local sentiment. It's sort of a balancing act. And in approving Sunlight Long and possibly this pad, which we're talking about unprecedented, overwhelming local opposition, the commission is showing that it either does not have the will or the power to be anything more than a verifier of checkboxes. When people are discouraged at the state of democracy in the United States, this is why. The final commissioner comments on setback distances were basically, we looked at it and we set it at 3,000 feet. And these commissioners apparently have very strong faith in these sensor studies that don't account for low levels of compounds persisting below detection limits, undetected side products when volatile organic compounds react with atmospheric conditions like sunlight or wind. They also have strong faith in these EPA limits, which are derived from things like animal studies or looking at humans in situations of very high exposures like certain occupations or maybe levels of ozone generated. These aren't good models. They take stock in these uncertainties in the face of growing evidence of strong association with childhood cancer that the county did not incorporate or consider. And this is a negligent act, and because the commission is a secondary check. In the years ahead, when people are discouraged at increasing childhood cancer rates, this is going to be why. The alternative location analysis seemed to be swayed by the interests of one rancher. By the way, at the edge of the Lowry Range, we see cows all the time. They roam all over. I have a hard time believing one location of approximately equal square footage versus another substantially changes the amount of grass available for grazing. Certainly, that one rancher would not want a fracking pad close to them, but why do their interests overwhelm the entire community? The front-running alternative site was rejected due to, quote, more miles driven, but the community did not have time to weigh in there. Perhaps local risk to health outweighs slightly higher emissions. You made that decision for us without any deliberation or input. So the fact that there was no deliberation, I think we should go back. Finally, one commissioner commented on quote unsavory actions by certain individuals. I found this to be frustratingly non-specific. What actions are you referring to, and ultimately, why should this factor into your decision? That's it. My time's up. I mean, I have a little bit more, but I'm going to respect the time.
Thank you very much, Mr. Wu. Appreciate you being with us, and drive safely.
Thank you.
All right. We now will hear from Randy Willard, followed by Andrew Pinkowitz, and then Alejandra Melanera. Mr. Willard, you're up. Go ahead.
Good morning. Thank you, commissioners, for hearing our comments today. My name is Randy Willard, and I'm speaking in my role as president of Save the Aurora Reservoir. So here we are again on a Wednesday morning. I sometimes wonder how the theory of insanity applies to these efforts. Nonetheless, I'm here to request that the commission deny a permit from our friends. Today, I would like to share with the commissioners something that many of us have been discussing. I could implore you with facts and figures that show this pad is as bad as many others proposed along the Front Range for both its proximity to humans and its density of emissions. We could talk about 100% increased risk of ALL leukemia in children living near wells within 3 miles compared to those that are not. We can talk about the cumulative impacts of continuing to permit in Weld and Arapahoe counties, combining to create abysmal air across the metro area much of the year, which is compounded in these summer months. I'm going to let others address these concerns, which apparently are not represented by a checkbox in any form. I want to impress on the commission today that it is fully within your rights and power to deny permits, even permits that check all the boxes. Without a path to denial and with only public comment as a weapon, the public has no option to impact any application anywhere in the state. Add to this the arrogance of the industry wherein any completed application deserves to be permitted, no matter the human or environmental costs. Rule 307 of Senate Bill 19181 clearly lays out the discretion the commission has. The commission can rely on its expertise to protect public health, safety, welfare, wildlife, and environment. This includes all the people living within range of these developments. Will it be 5 years or, God forbid, 10 years before massive studies show the impacts of continuing to permit these damaging and questionably profitable projects next to neighborhoods, schools, and homes? Our rules are 2 to 3 years old and were heavily inflected by industry sources. So I urge the commission to reopen the rules and allow current science proven research to be used to update them. 9,000 peer-reviewed studies compiled in the PSR compendium are probably not all wrong. To close, I urge you to consider the discretion that is provided to you in our laws. Deny or stay Blanca West until we fully understand to what extent the already permitted wells inflict harms to the people who live here. Deny Blanca West because of its proximity to 2 Cherry Creek schools, a county fairgrounds, horse track, and of course, the Aurora Reservoir. Thank you for your time today.
Thank you very much, Mr. Willard. We do appreciate your being with us and your continued presence and thoughtful comments. Andrew Pinkowitz.
Hello, Mr. Chair and Commissioners. My name is Andrew Pinkowitz. My wife, 2.5-year-old son, and I are affected residents of East Centennial in Arapahoe County, Colorado. Here's a picture of them. And I know you met Eli at one of the previous hearings as well. Though you already knew that. Today's speech marks my 5th public comment before the ECMC. Is anyone else here getting a sense of deja vu? In all the hearings I've observed for the Lowry Ranch Comprehensive Area Plan, or CAP, thousands of citizens from the community share overwhelming opposition supported by the latest proven science about the public health risks of fracking developments near families, elementary schools, daycares, and retirement communities, and yet this commission approves the fracking pads anyway. At what point do we consider these hearings to be entirely performative? Is this commission even pretending to consider a single iota of the information raised by the thousands of families affected by State Bronchitis West. Oh, that's right. This fracking pad is called State Blanca West. You know, it's hard to keep track knowing that the evolving, shape-shifting entity, now known as SM Energy and Crestone, formerly known as Civitas, admit in their own plain language summary document that they plan to emit pollution equivalent to over 72 million miles of transit from a passenger vehicle in an ozone non-attainment area. But you already know about volatile organic compound pollution. You know that families in close proximity, especially the children in our community, are at risk for grave health outcomes, including asthma, heart disease, childhood cancer, and birth defects. You know that Civitas falsified data from fracking sites in 2024. You know that the State Blanca West pad would operate for 30 years and is 0.6 miles from one of Aurora's main drinking water sources. And of course, you already know that the ECMC abdicated their responsibility of holding fracking operators accountable by failing to issue penalties for the 14,600 plugged wells where cleanup never took place, which overlap with more than 6,000 open spills where toxic chemicals contaminate soil and groundwater. How do I know you're aware of all of this? Because I've spoken with you at length at previous hearings about all of these facts. You know, there's a common saying that it takes 10 times to repeat a message before it sticks. And I deeply wonder if that applies to a commission who willfully covers their ears, exclaims, la la la, I can't hear you in response, and outright ignores the pleas from their constituents not to be poisoned. Though when this commission permits counsel representing SM Energy to interrupt witnesses during cross-examination, it seems wise to temper my expectations of basic human decency from you all. You represent the people of the state of Colorado. You hold the authority to protect those in our community who cannot advocate for themselves. Time to start acting like it. Deny the State Blanca West fracking pad to protect public health. Thank you.
Thank you. Alejandra, I don't even want to try to butcher your last name, but you're up next.
Mr. Chair, Alejandra is still declining the request. We'll try and get her elevated.
Okay, what about Kristen Dayton?
Yes, I'm here. Thank you.
Yeah, thank you. Thank you for being with us. We can hear you and see you.
Okay, wonderful. Good morning, commissioners. My name is Christine Dayton, and my family lives near the proposed State Blanca West well pad. A year ago, we moved here from South Carolina because we wanted to raise our children in a community known for its open spaces, quality of life, and a healthy environment. We never expected to find ourselves living near one of the largest proposed residential oil and gas developments in Colorado. Today, I have a child who attends Infinity Middle School, less than 2 miles from this proposed site. And like many families in this area, we depend on the Aurora Reservoir, a primary water source located just 0.6 of a mile from the proposed well pad. In a region already facing drought and water scarcity, the prospect of industrial drilling and fracking so close to homes, schools, and a critical water supply is deeply concerning. The concerns raised by this project extend far beyond my family. More than 10,000 households live within 3 miles of this site. That's a huge number, and I hope you're considering it. State Blanca West is part of a much larger development that could bring more than 150 wells, years of industrial activity, increased air pollution, and long-term impacts to nearby residents. Research conducted in Colorado has linked proximity to oil and gas development with increased risks of childhood leukemia, and the Denver metro area already struggles with some of the nation's worst ozone pollution. We know that spills, blowouts, and equipment failures occur despite any regulations you put in place. And when contamination occurs, cleanup is typically not timely or guaranteed. Investigations of Colorado's largest operators have found thousands of inactive wells and spill sites with unresolved environmental impacts, some remaining unremediated for years. That record matters because communities like ours are being asked to accept the risk today, and a strong possibility that any future cleanup obligations will never be funded or fully met. That's exactly why the legislature changed the mission of this commission in 2019. The ECMC is no longer tasked with fostering oil and gas development. It is tasked with taking care of our health, safety, welfare, and the environment and wildlife. Yet that change In that change, the commission's only denied 2 well pad applications. That record raises a serious question about whether the legislature's directive has been fully reflected in practice. The question before you is not whether this project can be permitted. The question is whether it should be permitted given its location, its cumulative impacts, and the risk it poses to thousands of nearby families. I urge you to put the health and safety of Colorado families first and deny the State Blanco West application. Thank you.
Thank you, Ms. Dayton. Appreciate you being with us. Do we have Yvonne Lau?
Yes.
We can hear you, so go ahead. And now we can see you and your son.
Okay. Hi, good morning, Commissioners. My name is Yvonne. I'm a mum and an impacted resident. I feel like I know you all so well because I show up at these meetings regularly. Ever since I learned that you are approving these wells that harm our babies, I urge you again to deny the State Blanco West OGDP pursuant to Rule 307. The language of Rule 307 is clear. It does not require you to approve a plan simply because it meets technical requirements or complies with existing regulations. Rule 307(b)(2) explicitly provides that the Commission may deny an OGDP if it determines that the plan does not provide necessary and reasonable protections for or minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Thus far, the Commission's authority to deny a project has been treated almost like a unicorn, written into the law, discussed often, but never actually seen. Yet your authority is real. You hold the power to protect. The Colorado legislature gave it to you through SB 181, and it is reflected in your own rules. 307. The people of Colorado did not need SB 181 to create another complaints checklist. Sorry.
It's okay. Take your time.
Protection requires more than checking boxes. Protection requires judgment and precaution when credible evidence of harm exists. For years, the public has presented evidence showing increased risks associated with living near intensive oil and gas development, including childhood leukemia, asthma, respiratory illness, and adverse birth outcomes. At what point does precaution become necessary? And are we waiting for children to get sick before we act? If the Commission believes there is uncertainty about the extent of its authority under SB 181, then the appropriate course is not approval. Rule 307(b)(3) expressly allows the Commission to stay consideration of a plan when additional information is needed. The Commission could also seek guidance through a formal Attorney General opinion regarding the scope of its authority and obligations under SB 181. I would also note that Commissioner Oath's expert health panel report has not yet been released. Before approving another decades-long development adjacent to communities, shouldn't the Commission review the findings of its own expert panel? Finally, during the Sunlight Long hearing, Commissioner Robbins, you stated that the applicant is entitled to application of the rules on the books at the time of the application, and those are the rules you are applying. Respectfully, that is not what Rule 307 says. The Commission's responsibility is not simply to apply setbacks. If compliance alone guaranteed approval, Rule 307(b)(2) would serve little purpose. The denial authority exists precisely because there are circumstances where compliance is not enough. This is one of those circumstances. You have the authority to deny State Blanco West. You have the responsibility to protect the people of Colorado. And under Rule 307, you have a clear and legal basis to do so. I respectfully ask that you deny State Blanco West. Thank you.
Thank you for presenting with us this morning. I see the next person is Tom on my agenda, and I see a Thomas Yeager with us. So I'm just presuming you're the same Tom that's on the agenda.
Yes, I am Tom Yeager, resident of Colorado, commenting on the Blanco West docket ending in 109. The testimony we have heard today is not new. We have heard these same arguments through and through. But let's go ahead and beat some more dead horses. Colorado law now requires the ECMC to prioritize the protection of public health, safety, welfare, wildlife, and the environment. Have you ever heard that before? Speaking of dead horses. But money breeds corruption. And those are things the oil and gas industry has plenty of: money and corruption. SB1 was supposed to make us safer, but corruption blew that into the air. Like, I don't know, a Chevron well? An obvious reference to the Bishop Well blowout. Another dead horse. As Ms. Lau just commented, and I quote her, the Commission's responsibility is not simply to apply setbacks. If compliance alone guaranteed approval, Rule 307B2 would have no purpose. But Mr. Robbins has said, if you tick all the boxes, if you meet our robust regulatory regime, you are deserving of a permit approval. That's a very flawed philosophy. Robbins, it is time for you to resign or be fired, along with Julie Murphy. Under your guidance, the ECMC has failed at making rules that protect the health, safety, and welfare of Colorado. And I'm not even going into the whole financial assurance catastrophe reported in The Guardian yesterday. Moving on to another dead horse, children and air pollution. We all know how the Front Range is the non-attainment for ozone, dead horse. According to a University of Colorado study, oil and gas operations account for about 45% of the Front Range emissions for nitrogen oxides and 41% of volatile organic compounds, the two biggest ingredients of ozone. Air pollution, especially ozone and fine particulate matter, has been linked to increased risks of premature birth and low birth weight. Specifically, medical literature has found a connection between fracking and premature births. So it bewilders me to hear of a mother, one who works for the industry, praising plastics for from petroleum for saving her premature baby, all the while ignoring the fact that oil and gas production could very well have been the cause of that prematurity. I'm looking at Jamie Jost on that one. So why don't you all ride the dead horse, do your fracking jobs, and deny the permit? Thank you.
Thank you. We now will hear from someone named Diane. Is that right? Hearings Manager Thomas?
Diane is not yet agreed to be elevated. We're working on it, so I will let you know.
All right. Melissa Haberim. I see a Melissa H. on our panel.
That's me.
You.
Okay, can you hear me?
Yeah, we can hear you and we can see
Okay.
you. Good morning.
Good morning. My name is Melissa. I'm a mother and veteran and also an impacted resident. I'm urging you to deny the State Blanca West OGDP pursuant to Rule 307. You have the authority to deny this and protect our community. We have previously presented evidence showing increased risks associated with living near intensive oil and gas development with increased the risk of cancer in children. My son said to me yesterday, Mom, I don't want to have to move away from my friends. I love our neighborhood. This is not fair to our children. Our children's health and safety should be our top concern. Additionally, we have not seen the Commissioner Oath's expert health panel report. Before approving another decades-long development close to communities, shouldn't the Commission be reviewing the findings of its own expert panel? You have the authority to deny this. Please do the responsible thing and protect our community. This is what you're appointed to do. On April 5th, 2025, an explosion at the Chevron well pad in Gallatin caused an uncontrolled release of more than 3 million gallons of oil, gas, toxic water, and chemicals for over 5 days. Homes within a half a mile were evacuated. Residents were exposed to hazardous substances, and entire properties were sealed off. Benzene, a known carcinogen, was detected more than 3 miles from the site. Chevron was using Colorado's so-called best management practices. Accidents like this do and will happen. If a similar explosion occurred at State Blanca West, thousands of residents would have to be evacuated. This would be a catastrophe of major proportions. Why is the ECMC willing to gamble with the lives of Coloradans? Most recently, Aaron Barakovich recently wrote about our community, urged us to continue using our voices, and so far we have not felt heard by this commission. You have a legal responsibility and moral obligation to do the right thing. Please deny the State Blanca West for our children's future. Thank you.
Thank you, Melissa, for being with us this morning. I believe we've got Representative Ricks now with us. Rep Ricks, are you there?
Yes, can you hear me?
We can hear you and we can see you. We see actually two of you.
Oh, really? Okay, I'm so sorry.
It's okay. Go ahead.
Okay. Good morning, everyone. I'm State Representative Ricks, Nikita Ricks, representing House District 40, my community. Um, I want to thank all of you for being here and for having this hearing and giving me an opportunity to speak regarding this matter. This issue before us is not a distant or theoretical one. It is happening in our backyards, my backyard, in my neighborhood, and in our schools. Fracking is not just an environmental debate. It is a public health crisis, and the evidence to support that is overwhelming. The commissioners on this panel have heard all of this. You know the risk for these families. You know the risk for our environment. You know the risk for our wildlife. Colorado is feeling the consequences of this crisis firsthand. Communities across our state, like Aurora, Firestone, and Erie, are living with fracking operations that sit dangerously close to homes, schools, and parks. Residents can smell the emissions from their front porches, watch the flares burn through their bedroom windows, and feel the ground shake beneath their feet. In Aurora, residents and advocates have repeatedly raised concerns about proximity to oil and gas operations and what their families are breathing every day. In Firestone in 2017, you've heard this story again and you know this, two men, Mark Martinez and Joey Irvin, were killed when a gas line exploded, just 178 feet from a restarted gas well. In Erie, a community of 117 producing wells within its borders, residents report migraines, burning throats, coughing fits, nosebleeds, dizziness, headaches, and asthma flares, with some neighbors living less than 500 feet from active sites. These are not hypothetical risks. They are real families, real homes, real lives that have been destroyed. It is past time that we act. For our children, the risks are often most severe. Because of their developing bodies, children absorb toxic chemicals at higher rates than adults and are more vulnerable to environmental hazards. Consider what that means for children spending their days at playgrounds and schools within a miles of active drilling sites. These are children who have no say in the matter and no way to protect themselves. Research has shown that the children living near fracking sites are at measurably higher risk of developing asthma, certain cancers, and other serious illnesses. No parent should have to weigh their child's health against the cost of their mortgage. This is not a choice any family should be forced to make. Moreover, the health impacts of fracking extend even further than most people realize. Chemicals used in the fracking process have been detected in water sources, in the air near drilling sites, posing a very serious threat to both the environment and people living near these developments. Research from the NIH found that adults living near a downwind of unconventional oil and gas sites face a higher risk of premature death than those living upwind. Wildlife and ecosystems suffer too. Well paths, roads, and pipelines destroy breeding grounds, disrupt migration routes, and displace sensitive species. The damage does not stop at our properties. At issue close to home, my community, the Crestone Peak Resources Operating Blanca West OGDP, the one that we're talking about right now. I want you to know that this proposed site is right there in Arapahoe County. Crestone Peak Resources has submitted an application for 18 oil and gas wells on a pad site roughly a half-mile south of Quincy Avenue, a half-mile north of East Reservoir Dam Road. That's my community. That's the heart of my community. To paint a picture of how many people in this development could be impacted in Blackstone, Gun Club, and Quincy area alone, there are approximately 278 homes up for sale in Blackstone. And I don't know if any of you have gone to Blackstone to visit. This is a beautiful community, higher end homes. And these people are going to be impacted by these oil and gas wells. On Gun Club, around over 171 in Quincy, townhomes, condos, single family homes are being impacted, and those homes are listed too. So basically, what this is going to do is to decimate this whole community. And it's unfair. People have bought their homes, they've come there, they're enjoying it. You heard a lady talk about her daughter who doesn't want to leave their home because they've made friends there in schools. You're disrupting huge communities. This is not right. And if you have the ability to stop this, please look at this. This is not just a concern for me as a legislator, it concerns me as a neighbor. These neighborhoods are the heart of my district and the place that I'm proud to call home. Every family is looking to move into these communities, deserves to know what they're moving in. And every family already who is living there is looking for a better life. And we owe it to them. We owe it to Colorado families. At a time when we're talking about affordability and how high it is for mortgages, these families have purchased homes. They deserve to have peace and good air, clean water. That's all we want in the environment. In closing, the health of these Colorado families should not be negotiable. Clean water and air are not privileges. These are rights. Every community in this state, especially those that have been raising concerns for years without being heard, deserve a government that takes them seriously. We really strongly urge you to do what you can. I know that there's been deals made with the current governor, etc., but we will be coming with legislation to try to stop this. And we especially ask for you guys to act in the interest of the people of Colorado and not just the oil and gas companies. Thank you.
Thank you, Rix, for being with us. I think we now have Sandra Dugan, who's logged in under 350 Colorado.
Yes,
Is that
hello,
you?
commissioners.
Good morning.
Good morning. My name is Sandra Dugan. I'm a coordinator with 350 Colorado and a Colorado resident personally impacted by fracking. I'm here to voice 350 Colorado's opposition to the State Blanca West project. Oil and gas is a bad neighbor. They have proven that time and time again. The experience of being fracked is one that I wouldn't wish on anyone. Fracking operations expose nearby residents to continuous, sustained noise pollution, light pollution, and related stressors. Furthermore, living near Colorado fracking sites poses significant health risks, including increased leukemia risk in children, respiratory issues, and cardiovascular problems. Today, I want to address something bigger than the plight of any individual community's opposition to fracking in their backyard. I want to talk about the cumulative impacts of fracking in our state. Colorado's air quality continues to worsen, and we are facing a drought emergency. Human-caused climate change pushed up average Colorado temperatures 2.3 degrees Fahrenheit from 1980 to 2022. According to Colorado State University's 2024 climate update, the temperatures are estimated to rise an additional 2.5 degrees Fahrenheit to 5 degrees Fahrenheit by 2050. 4 of the driest water years in 128 years of records have occurred since the year 2000. Denver is the 8th most ozone-polluted city in the nation. Oil and gas fracking is a leading source of climate pollution and the severe ground-level ozone pollution in Colorado. And as you know, in 2019, Colorado passed SB 19181, a law that requires that Colorado oil and gas policy prioritize the protection of public health and safety over oil and gas extraction. What we have seen since that law was passed has been incredibly disappointing. Since 2021, over 70 locations, many with dozens of wells, have been approved closer than the 2,000 feet setback from homes. In fact, the state has permitted roughly 1,000 wells per year in recent years. This is in no way protective of Coloradans and our environment. The truth is that the state has not effectively addressed the cumulative impacts of continuing to conduct business as usual. What we are asking for today is for you to look beyond the precedents that have been set and act on the best interest of Coloradans who are already facing the consequences of a rapidly warming climate. Today, we are asking you to act in accordance with your mission change. We are here to remind you that you are tasked with regulating, not fostering, oil and gas development in Colorado, and that you are meant to evaluate each OGDP individually. Furthermore, Rule 307 explicitly permits denial when an application poses risks to public health and safety. You would have no trouble justifying a denial of the State Blanca West OGDP. On the contrary, I invite you to see this as an opportunity to truly act in a manner that protects public health, safety, welfare, the environment, and wildlife resources. Thank you.
Thank you, Ms. Dugan. I appreciate you being with us. I believe we now have Bill Cresser.
Yes, thank you. Can you hear me?
Yes.
Yes, thank you for allowing me to speak. A recent story published by the Colorado Sun discusses the history of 100 years of arguing for or against the way in which fracking wells are permitted and located. I learned that setback distances were originally set at 150 feet so that if a drilling tower fell over, it would not hit a nearby home or school. Later, the distance was extended to 300 feet. Recently, the Arapahoe County Commission decided to set a 1,000-foot setback distance for wells within their county, thinking that this would be an extra margin of safety. But science has moved forward, and setback rules set by the ECMC have missed a recently discovered danger. The ECMC is tasked with promulgating rules that protect the health and safety of nearby residents. A few minutes ago, other speakers have mentioned many different chemicals which might have an adverse impact on the local residents and were emitted and detected. Now we have scientific proof of the harm, thanks to a 12-year study by the Physicians for Social Responsibility. They have published a compendium of 2,000 scientific studies published in highly respected journals, refereed by other scientists unrelated to the researchers. The most recent study was an epidemiology study of a fracking site here in the Front Range of Colorado, similar to the fracking sites we are discussing today. The actual deaths and illnesses within 8 miles of the fracking site were measured for 5 years, and these were compared with nearby neighborhoods of similar demographics, but further than 8 miles away. The evidence was very clear. A dramatic increase in childhood leukemia and other deaths and illnesses was seen within 8 miles, but not seen in other places. Epidemiology is not a fuzzy science. It doesn't allow opinions to come in like opinions come in for almost all of the other rules that the ECMC has set. The statistics used in epidemiological studies make sure that the opinions of the researchers have no way of entering into the results. So this is the gold standard for judging impacts, used highly in the East, where I work to help companies avoid harming their neighbors. And we now have it here. We have proof that these concerns are actually dangerous to us and should be taken into account by having the ECMC rewrite that particular rule. Thank you very much.
Thank you, Mr. Cresser, for participating with us. We now will hear from Nathan Lyon.
Thanks. Can you guys see and hear me?
Both, yes.
Great. Good morning. My name is Nathan Lyon. I really struggled with these comments today. I've been through this ECMC process enough times that I know the lay of the land. It's become clear that many commissioners purely believe this hearing is to do their best final check to make sure the applicant has checked the boxes of regulations and not instead to have the discretion of upholding the ECMC's mission. But the thing is, the applicant is given so many opportunities throughout the process to correct errors, modify, get exemptions, drop in BMPs, etc., that the application should check all the boxes when it arrives to you. And so, as a public commenter, instead of being able to tell you the reality of our community and why this negatively affects us, which it does, we have the burden of looking through all the application files and the regulations and trying to find the loophole that the applicant forgot to take advantage of. Now, luckily, in this case, the Blanca West application does not meet Arapahoe County regulations, and I can prove that at a later time. But for today, I'll leave you with some very concerning information about this site. If you were to think of this site purely through the lens of your mission, would you still find the site to be protective? And is it possible that SB 19181 intended for you to have the discretion in your decision to account for things that weren't written in your rules? Things so reckless, maybe even nobody thought of putting them in there, like fracking right up to the edge of a federal Superfund site, or destroying millions of gallons of fresh water during a drought. But since this commission is so focused on 2,000 feet for everything, here are a few concerning areas that fall within that invisible protective line. 0 feet to high priority habitat for 850 feet of the access road, not protective of wildlife resources. Pad surface 189 feet from mule deer winter range, high priority habitat, not protective of wildlife resources. Pad surface 560 feet to a surface water feature, not protective of public health, safety, and the environment. Pad surface 1,518 feet to the City of Aurora's Pronghorn Natural Area, not protective of wildlife resources and public health since it's a public use area. Pad surface 1,971 feet to Quincy Road, a high use public road and the fire response route for this very site, not protective of public health and safety. I'm sure you guys have already all looked at all these distances that fall under 2,000 feet. So there is a bunch of reasons right there why you can and should deny this application. But we know how this goes. Thank you for your time.
Thank you. Next, we have Emily Arano.
Can you hear me?
Yes, we can.
Great, thank you. I'm trying to find a good spot to sit to give my comments. Thank you so much for being here, and I hope that you guys do something with our comments, not just hear us and then do what you were planning to do, but actually do act on our concerns. It doesn't seem like there's anything in your mission or in SB 19181 that says you can only take into account the health and safety when the permit was written, because things have changed since the permit was written. We're in a drought and the community has grown up around the proposed site for Blanca West. You are actually allowed to take into account that things have changed since the permit was written, and the public sees that and hopes that you will act on your authority to take into account the way that things have changed. In addition, The public knows that you have the authority to consider things that are also considered by other agencies. So I don't see anything in any of your rules or your mission that says you are not allowed to consider things like water or air just because they are also being considered by other agencies. I have seen this political hot potato where everyone gets to pass the buck off to some other agency and nobody has to take responsibility for making the final decision. And I hope that you guys will be a hero for the public today and take responsibility for doing the right thing. Thank you.
Thank you. Next, we have Linda Carey.
Can you see me okay and hear me?
We can, yes.
Good morning. My name is Linda Carey, and I live in this area where this proposed site is going. We all know that fracking requires injecting not only water and sand, but proprietary chemicals deep underground. It's right next to a reservoir that provides drinking water to people who didn't ask for this, and all they're trying to do is raise their families and live their life. Clean drinking water and clean air should not be something we have to continually fight for. But we see it all the time with corporations being allowed to do things in areas that they should not be doing it. You know, we've seen that corporations taint an area, people are affected, get sick. After the fact, the corporations are found guilty. Sometimes they pay reparation, sometimes they declare bankruptcy and open up under another name after the damage is done. We're trying to prevent that damage being done to all of these families. How would you feel watching your child get sick, fighting leukemia from the water you gave her, from the house that you raised her in? How would that feel as a parent? Unbelievable, because when we buy our houses, as parents, we're doing the best that we can to find a safe area, good schools, and just providing them the best life we can. Prevention and precaution should come before industry profits. The ECMC has both the authority and responsibility to deny this project. For the love of our children, humanity, wildlife, environment, and safety, please deny this application. Thank you.
Thank you, Linda, for being with us. We now will hear from Preeta Patel.
See me?
Yeah, we can see you and we can hear you.
Awesome, thank you. Good morning, commissioners. My name is Preeti Patel, and I am an impacted resident who urges you to deny the Blanca West Oil and Gas Development Plan. Senate Bill 181 set a clear standard. Public health and safety come first, not just as a factor to be weighed against economic benefit. However, the decision-making process at both local and state levels demonstrates that the standard is not being applied as intended. Instead, what we get is a series of steps to check the boxes. Was a health impact assessment submitted? Check. Was a public notice posted? Check. Were comment periods provided? Check. It turns out that none of these actions equate to a thorough analysis. The question is not whether the application meets the requirements, but whether the impacts on public health, safety, welfare, and environment have been fully considered and evaluated. In early 2021, my husband and I purchased a home in a beautiful neighborhood with zero knowledge that massive industrial fracking operations were being planned nearby. It is the same story for so many families. Information is incredibly hard to find, with documents written in a manner that cannot be easily understood. Deadlines come and go before most people are aware they even had an opportunity to provide input. And it doesn't stop there. When applications flood in faster than the public can keep up with and respond to, and approvals are issued 99.9% of the time, the process tips heavily in favor of industry, leaving the people with no voice or representation. Industry has the lawyers, lobbyists, and staff to keep up with this chaotic pace. The people do not. This is not a fair or equal process, but a broken system intentionally designed to discourage any form of meaningful public participation. Colorado is in a drought. That is not a backdrop to this conversation, it is central to it. And yet, this project proposes 18 new fracking wells, each consuming between 20 and 25 million gallons of water that will be permanently destroyed. To make matters worse, this site is located less than 1 mile from the Aurora Reservoir, which is the primary drinking water source for nearly 400,000 people. One spill, explosion, or misstep would compromise the very water supply our community depends on. In other words, this is a disaster waiting to happen. Commissioners, the ECMC has clear authority to deny this application, and you are under no obligation to approve it. Rule 307 explicitly permits denial when an application poses risks to public health and safety, risks that are evident in this proposal. I respectfully ask that you deny Blanca West. Thank you.
Thank you for the comments. Shayna Oliver.
Hello? Can
Hi.
you hear me?
We can hear you. We can see you. Yes.
Thank you. My name is Shayna Oliver, Indigenous Peoples' Rights Advocate and Field Organizer with Moms Clean Air Force, Echo Madres, Colorado. We are 44,000 and over parents united to protect our children's right to live, learn, play, and breathe clean air in a safe environment. Moms Clean Air Force and Echo Madres urge your leadership to consider children's health and maternal reproductive health by rejecting the state Blanca West project. Families across Colorado are enduring public health impacts from increased encroachment of oil and gas near our communities. Longtime sitting commissioners have heard parents plead to protect our children from the environmental health impacts of oil and gas. A recent article from The Guardian states that there are thousands of old drill sites in Colorado. The state gave oil firms a $1 billion pass, giving us clarity of leadership that continues to put industry economies over children's health protections that are supposed to protect disproportionately impacted communities faced by environmental burdens caused by polluting industries. As moms, we know oil and gas sites and operations expose families nearby to high levels of methane emissions, along with many other harmful co-pollutants like benzene, nitrogen oxide, and hydrogen sulfide. These harmful pollutants are known to increase risk to certain forms of cancers, adverse birth outcomes, including preterm birth and low birth weight, central nervous system toxicity, and respiratory harm. The EPA also made strong concerns of drilling in close proximity to Lori landfill Superfund site would put the Aurora Reservoir at risk. Concerns have been raised that any seismic activity from drilling would jeopardize the containment and allow contaminants to enter an aquifer system that millions of Coloradans rely on. And in Colorado, Greeley, Denver, and Aurora are still the top 10 polluting cities for ozone pollution. There are no safe levels of harmful pollutants. Smog pollution is linked to increased risk of heart attacks, hospital visits, adverse birth outcomes, and impacts on respiratory systems. Over 300,000 Coloradans are living with asthma, like myself and my son. Nearly 18 million individuals across the United States live within 1 mile of an active oil and gas well. Colorado Moms Clean Air Force, Echo Madres call for your leadership to reject the state Blanca West project. Our children are counting on us and in your leadership. Please consider children's health and reproductive health. Thank you.
Thank you, Ms. Oliver. Appreciate you being with us. And we now have Martha.
Hello.
Good morning.
Good morning. Hi, my name is Martha, and I'm an impacted resident of the proposed Blanca West fracking well pad. I am a mother, and my young toddler has young cousins and grandparents in the area. But even if I didn't have a personal stake in this, I would still be here to urge you to deny Blanca West for the good of others. Colorado is supposed to be full of clean mountain air, but instead it's full of pollution from oil and gas. Please don't let our beautiful state descend further into this industrial hellscape. You say you are protective of the public and you pride yourself in having robust and protective rules. So please walk that walk and step up to protect the public now and deny Blanca West. There is a wealth of research showing that proximity to fracking sites is significantly harmful to health, especially that of children, elders, and the immunocompromised. The most vulnerable members of our community, those that need the most protection. You must live in the present moment and take that information on board to deny Blanca West. The rules and setbacks you had before will not do anymore, given the current research. So you need to update yourselves and take appropriate action. Deny Blanca West to protect the public. It was alarming to hear you, Commissioner Cross, say that Sunlight Long couldn't be denied because that would open up the whole can of worms of what you have previously approved. Does that mean then, dear commissioners, that you are not acting according to what's right, but according to what has fewer adverse consequences for yourselves? A real leader steps up and does the right thing, even if it leads to awkwardness or difficulty. You know now the public isn't protected when fracking sites are so close to neighborhoods. Please don't proceed to inflict harm just because you can't be bothered to face your past actions. Respond to this information and deny Blanca West. Don't be complicit in increasing the instances of childhood cancer, poor health, and deaths. Be leaders and deny Blanca West. Thank you for your time.
Len, you're up next.
Hello, my name is Lynn Sullivan. I'm commenting on docket number 250-600-109. As a Colorado resident deeply impacted by the critical decisions this commission makes every day, I'm very grateful for the opportunity to speak with you today. And it's important to speak about facts, especially in light of the recent ECMC report that Civitas Crestone has falsified data and outright lied about things like the number of environmentally hazardous spills occurring at their facilities. The most important fact to consider today is the ECMC's mission, which is to regulate the development and production of oil and gas, amongst other practices, in a manner that protects public health, safety, welfare, the environment, and wildlife resources. I'm here today to ask you to uphold your mission. To do this, you will activate your roles as protectors of the health and welfare of everyone who lives and works near these proposed wells. Every approval you grant has cumulative negative effects on the quality of drinking water, air, and the long-term health of nearby communities. And these cumulative effects must be taken into consideration. The ECMC has the authority and responsibility to deny projects that do not uphold your mission of protection. Therefore, it's imperative that you don't grant this permit because it does not protect public health, safety, welfare, the environment, or wildlife resources. You have heard the long list of health hazards these wells will pose in this location. Instead of repeating them, I'll ask you to simply uphold your mission by denying this permit, thereby protecting the communities you're mandated to serve. Thank you for your work and your time spent considering your vital mission to protect us. We are all counting on you. You have the authority and mandate to deny this application. Please do so, because its approval would be a violation of your mission and will be foundationally detrimental to the health and safety of thousands of families who live nearby. It's just a matter of time. Thank you once again for taking your mission to heart and manifesting it in your practices and decisions by denying this permit and truly protecting us. Thank you very much.
Thank you, Ms. Sullivan. We now will hear from Teresa Launder.
Yes, good morning. Are you able to hear me?
Yes.
Very well. Good morning, commissioners. My name is Dr. Teresa Launder. After getting my MD from the University of Colorado School of Medicine in 1989, I completed a 5-year residency in pathology, the study of disease. And I did an additional 2 years of training, and I am board certified in the diagnosis of blood cancers, including leukemia and lymphoma. For 33 years, it was my privilege to assist in the diagnosis and management of these diseases. And I have seen the toll that they take on patients, families, and our beleaguered medical system. I have lived in the Saddle Rock North neighborhood of Southeast Aurora since 2001, raised my kids here, and retired here in 2022. As an impacted resident and a physician, I urge you to deny the state Blanca West pad proposal. There is no doubt that oil and gas drilling and fracking technologies are associated with increased risk of childhood leukemia and other blood cancers, including those that affect our older adults, such as CLL and myeloma. A very good, well-controlled study on childhood leukemia risk in Colorado was published in 2025 by my alma mater, which is now at CU Anschutz. We've already heard that risk is elevated within 3 miles of a site, but I can assure you that that risk, if you read the details of that study, is actually on a continuum, showing increased risk out to a distance of 8 miles from a site, comparing kids with and without cancer. So even if projects meet designated setbacks, those setbacks are inadequate. It is my understanding in my first appearance before you that this commission has the responsibility to protect public health and safety and the authority to deny this application under Rule 307. I urge you to do so. This dirty and expensive technology is not what Colorado needs in 2026. I do not want my community to become yet another cancer alley when we knew better. Thank you for the opportunity to speak.
Thank you, Dr. Launder, for being with us this morning. Next, we have Sally Ingen.
Sorry about that. Okay, good morning, commissioners. First thing, Commissioner Robbins, perhaps you can listen to the recording when you do not have so many distractions. There's a lot of people who care a lot here and want you to hear what they have to say. If you recall, I've spoken here many times before. I have 2 grandsons, ages 6 and 9, that I watch frequently. I live about 1 mile east of the new fracking pad that 3 of you agreed to approve. If you're familiar with children, you're familiar with this statement. Go outside and play, usually followed by "you're driving me nuts." My home is on a couple-acre property. There are a lot of trees for kids to climb, a swimming pool to play in, and room for any type of game a kid can dream up. Well, I can't say that statement anymore unless I check which way the wind is blowing. If it's coming from the east, I'll have to keep them inside. Do you have to worry about that in your homes? Nope, none of you live close enough to these monstrosities to have to think about which way the wind is blowing before you step out your front door. We installed one of those gadgets that tell us which way the wind is blowing for our safety. Do you have one of those? Because your very lives depend on it? Do you? Anyone? Probably not. Are you researching currently which air purifier to buy when you have to stay safe inside? One that removes benzene, toluene, a plethora of chemicals that are dangerous to all life? Are you guys researching air purifiers? You could have voted no on Sunlight Long. It is not mandatory to prove an oil and gas application just because the boxes are checked. Many previous commenters have already addressed this problem, so I will not. All that I can surmise for your reasoning to approve every well is that you're in fear that big, bad oil and gas will sue the state if you deny something. So much in fear, in fact, that you are willing to risk the lives of everyone within an 8-mile radius. Read the room, please. Alternative energy is on its way up, in many cases surpassing old methods of energy. You must have seen the evidence by now. Oil and gas is on its way out. Every day there are new scientific discoveries making oil and gas obsolete. And yes, science is winning. What side of history do you want to be on? The one that does the right thing to protect the people and the planet? Or the one that cowers in fear because there's a Goliath or some other powerful politician breathing down your neck? We do not need any more cowards. We need you to die this well pad and many more to come. Thank you.
All right, next we have Lauren Malam. You're muted.
Can you see me and hear me?
Yes, we can. Thank you.
Okay. Hi, my name is Lauren Milam, and this is my family, my husband and my 3 children. I have 2 boys and a girl. I am reaching out to you because I am extremely fearful, deeply troubled, and significantly concerned for my family and the residents of Southeast Aurora, including my friends and neighbors. I strongly oppose the State Blanca West well pad for numerous reasons. The first being water, our most vital and necessary resource for life. The State Blanca West well pad's proposed location is northeast of Aurora Reservoir. Numerous fracking pipelines are going to run under people's homes, many schools, several parks, playgrounds, churches, businesses, and Southlands Mall. Eagles have been nesting the last several years in the open space just east of East Quincy Highlands community. If this well pad goes in, the eagles will no longer nest there because of the lights, noise pollution, and being so close to heavy machinery. Also, State Blanca West well pad has well lines that run right up next to the Lowry Superfund site where hazardous waste is kept. A new docuseries called Toxic Ground by ProPublica was published on June 2nd, 2026. As reporter Nick Tomlin states, this is a huge environmental and public health crisis right below our feet. Nick Tomlin explains how fracking sites in Oklahoma put oil wastewater deep into the ground, causing ground pressure to produce earthquakes. If the oil and gas industry pumps the oil wastewater at shallow depths, the pressure builds up and it cracks the rocks, contaminates the groundwater, and then purges through old orphan wells, which are old wells that have been abandoned by the industry and not properly plugged. We see this go on with 2 different families. One had a well that was back from the 1930s, and their house was literally built on top of the well. They saw the oil come up through their floorboards, through their shower and sink drains, through their toilets, and their house was unusable. It was considered a complete and total loss. They also had to file for bankruptcy because they couldn't afford to keep the house. Then with another family, their water was so badly contaminated that it had 72% of the EPA's recommended level for contamination. 72%. If the oil, who's to say that intense pressure from pumping the wastewater underground won't disperse the hazardous waste from the Lowry Superfund site, go into our groundwater, contaminate our groundwater and the Aurora Reservoir, just like it has done throughout Oklahoma. Aurora Reservoir is Aurora's drinking water source. In yesterday's Guardian article, it states 90% of these spills occur within 500 feet of an oil and gas location, but more than half, 53% of reported spills are not associated with a specific location. It's not a matter of if it gets contaminated, but when it gets contaminated. When this fracking well pad is abandoned and not properly plugged, then purges and contaminates the groundwater and the drinking water, what are you going to do? How are you going to supply water to the 10,000 plus families that live in Southeast Aurora? Our drinking water is not for sale, and you have no right to give it away. We are talking about over 10,000 families not having drinking water for them to live, not for them, for their children, their pets, their homes, or their yards. Starting in May, all of Arapahoe County was put on water restriction. How did big oil and gas get first priority on using our clean water, drinking water for fracking? And that's not all they're getting a pass on. The article published in Guardian titled, "There are thousands of dirty oil wells cited in Colorado," says that the state gives oil firms a $1 billion pass. Let me read from the article. Major reforms gave the ECMC an opportunity to solve the problem in 2019, but rather than using those powers to hold the biggest companies accountable, the agencies found new ways to let them off the hook. ECMC, I'm asking you not to let them off the hook. Please deny State Blanca West. You don't have to approve it just because you approved all the other ones. You don't have to approve it just because it checks all the boxes. As we know, there are harmful pollutants that go into the air. And contaminate the air. If the oil wastewater gets into our water, it can kill us. It can kill our kids. It can kill all the animals that live in our environment around us. I'm asking you to do your job and deny Blanca West. And please follow Senate Bill 181. Prioritize public health, safety, welfare, and the environment. Thank you for your time.
Thank you, Ms. Mellon. Kirk Manzanares.
My name is Kirk Manzanares. I'm a longtime resident of Aurora, Colorado. I don't have a prepared speech for today. I did give one last Tuesday, which was recorded, and it is out on YouTube and Instagram. I just want to say that we are going down a very dangerous path with allowing this fracking to take place. It's dangerous for the wildlife. It's dangerous for the reservoir. It's dangerous for our kids, for our family members. This is a catastrophic event for Aurora. And if you pursue with letting this company do these fracking wells, there is going to be somebody held accountable for what happens. If this turns into another Flint, Michigan, that is on your hands. I strongly urge you to pull these permits and to stop this immediately. I've reached out to Erin Brockovich, and I'm really hoping that she's going to get back to us and she's going to assist us in making sure that this is shut down and that what the damage that could be caused to the reservoir and to the community of Aurora is catastrophic. And you guys better really think twice about moving forward with this, because there is going to be millions and billions of dollars worth of damage done if you permit this to happen. So you guys need to really think about this and cease and desist. That's all I have.
Thank you. Diane Mock. You're muted, Ms. Mock. You're still muted. I'm sorry.
Okay, guys, I very much thank you for fitting me in this morning. I've had a doctor's appointment and technical issues, so thank you. Hello and good morning to all. I'm here on behalf of myself and my community. The governor, the AG's office, and the ECMC have put me and others in a precariously dangerous position. I now must decide if I'm going to move or just deal with air pollution, noise pollution, health threats, potential fracking, water accidents, and transport. I don't see the positives here for me or my community. And so I'm left with the decision. Do I move or do I stay? I am HD 40. The people in my community have voiced opposition, fear over all of this. And I think that we can learn from other communities that have already gone through fracking in their communities. Reported threats are a reality, and the same things that people in other communities have faced are on the horizon for Aurora residents. In a Guardian article, reporter Joe Fassler and his team of data specialists quoted the main interviewee, Van Wonderberg. The dream turned into a nightmare. He had moved into a community that he, like the Blackstone people and like all of us, had felt was really a great place to live. The dream turned into a nightmare, I quote. Loud noises rumbled all night long. The air stank like exhaust. neighbors starting getting headaches and nosebleeds. And over time, we have reported that this could be an actual outcome of fracking exhaust. So, and Vanderburg developed new respiratory issues, end quote. So not only are these people's fears, they are realities. You have all turned a blind eye and deaf ear to our comments. I say ditto to everything that's been said. People have obviously done their homework. It's no need for me to keep going. Your website states that you are here to serve the public, but it seems to me that the decisions have always been slanted in favor of oil and gas, not to mention the fact that the governor has put a moratorium, I believe it was for 2 years on this. I don't know. The AG has remained silent. And the problem is you keep citing the law that's on your side. Maybe part of it is on the side of oil and gas, but it also needs to be, we also need to be figured into this. You have the power to decline Blanca West permit. I hope you will use your votes to protect us. For once, I've been through a number of these hearings. You've probably seen me, you've probably heard me before. I just hope that you'll use your power of the vote to just deny the Blanca West permit. And really thoughtful, would you move here? Would you move here? Would you live here? I doubt that any of you live here. And we know why. So anyway, thank you very much for your time. Thank you for seeing me late. Bye for now.
Thank you, Ms. Mock. Hearings Manager Thomas, I see 5 more people that signed up that do not appear that they've showed up. Do we have anybody else?
That is the end of our public comment list.
All right. We thank everyone for the public comment this morning. Let's return at 10:45 for the first OGVP.
Michelle, if you want to test your slides out, go ahead.
Okay, thanks. Well, I should have changed my background too, but that's okay.
Okay, welcome back. Energy and Carbon Management Commission. We will continue with our docket this morning. We now have an ECMC Strategic Development Unit update. Michelle Berry.
Hi. Thank you for having me here today. I am Michelle Berry, the Strategic Development Manager, and I wanted to also introduce one of my teammates, or a member of my team, Dan Behill. He is also going to be speaking with me today. He is ECMC's Organizational Development Specialist. So a little bit about my role and what I do. I have been with ECMC for 10 months, and I joined ECMC and the DNR from CDLE, where I worked for the Family Division for 3 years as a strategic communications in a strategic communications role. My responsibilities include developing and implementing strategic training and mentoring programs, along with overseeing organizational development projects and supporting executive leadership with strategic initiatives, managing staff. I also coordinating cross-functional projects, facilitating organizational change efforts, and helping to align the agency with the agency goals with performance measures and operational priorities. A significant portion of my work does involve balancing competing priorities, managing some complex and simple projects as well, along with supporting organizational change initiatives and ensuring coordination across multiple areas of the agency. So here is basically our agenda for today. I'm going to give you some background about my unit and introduce my team to you and describe what we do for ECMC, along with outlining our strategic priorities. Because we're part of the strategic, or we're part of the shared services section, describe a little bit more in detail what we do. And then I'll turn it over to Dan and he'll talk about organizational development, and then he'll give the presentation back to me and we'll finish up and we'll end with some questions. So here we go. Sorry, just let me go to the next slide. There we go. There we go. So we are ECMC's newest unit. Technically right now I am still the newest manager in ECMC as well. That will not be, I will not be able to say that for much longer. We are part of the shared services section, and so we join QAQC and information, or an orphan well, and the information and technology section along or under the strategic services unit. And together, all of us provide support for ECMC. And this was, we were intentionally formed and included in this section and placed underneath the development, or the Deputy Director of Strategic Services, Paige Papillon, to be a shared services team. So the core purpose of my team is to build we're dedicated to build internal capacity for key organizational activities, specifically including strategic development. And as part of that, we provide support or administrative support for ECMC priorities. We respond to organizational needs, and we are growing and continuing and continuously changing to learn to better respond to these organizational needs as they come up. And we are continuing to define what we do and how we can create value for ECMC. And this is my team. I would like to just take a minute and celebrate a major milestone for my team. We are now fully staffed. As of Monday, June 1st, we added our newest team member, Liz Timmons. She is joining us as a digital asset and accessibility program manager. So we're excited to have her with us. So there's some other faces on here that you will be familiar with. Hannah, who is she is our program coordinator. She does a lot with employee engagement and employment. And then there's Cassie, along with Dan, who you'll meet later today. And then Anne was brought on to help with the Workforce Development Fund. And then last but not least at all is Darla. And Darla does a lot for our front office and spends a lot of time not only helping teams a lot, and also external stakeholders, the public, when they reach out to her for help. So this is a fantastic team of professionals that I work with. They have very diverse roles and expertise, and together we come together to provide shared services and provide critical support for ECMC. And we're talk about that next now. So as you can see, we do have a lot of different buckets that we do. And I mentioned before, we've been working to really build out that team in the 10 months that I've been here, which includes we've hired Dan and now Liz as additions to our team, and Anne was another addition to our team as well. So together, we provide support for project management, organizational development, program coordination, office management and administrative support, digital access management and accessibility, and also other technical support functions. So together, we do a lot of different things every day, and so it takes a little bit for us to come together and really talk about what we do and make sure that we can connect individually as well. But we do that, and we focus on that, and that is in part so we remain effective as a team. And in January of this year, we launched a shared services request projects and services request form. And this is and just one of many forms that ECMC staff use to interact with me and my team. So here are our strategic priorities. So these priorities really focus are on strengthening ECMC and building long-term capacity. So we've been working to enhance internal communications and foster a strong organizational development culture. We're working on developing and implementing strategic plans and roadmaps, along with increasing employee engagement, supporting leadership and workforce development, advancing accessibility, and improving the management and use of digital assets through systems, process, and training, which that is what Liz was brought in to do. So we're going to be focusing on that more going forward. So together, these priorities will help maintain or help ensure that ECMC, is aligned and effective and prepared to meet hopefully prepared to meet future challenges as they come up. So more about shared services and what we do. So with the expansive growth within ECMC, there was a lot of technical roles were added, and there was not always that administrative support. So we do provide a lot of that administrative support, and this is a short list of the many things that we do. A couple things I do want to highlight that we can also help with is, and that we do help with, is preparation for presentations and in presentation assistance as well. We do proofreading and editing. We help with project management. We help with proposals. We are really working to, or as we have evolved and as we have come into ECMC and as we've learned more about ECMC, we're really working to expand the ways that we can support staff. So one of the things that we really focus on is working to build relationships across the organization, and this is not only to decrease silos and communication, but also to increase the awareness of the strengths of my team and what we can do for ECMC and how we can help ECMC. So we work really hard to make sure we are working really hard to get those messages out. And I'll talk more about how we're doing that later, but I would now like to turn the presentation over to my teammate, Dan Behill. Dan?
Thank you, Michelle. Hi, my name is Dan Behill. I am the Organizational Development Specialist for ECMC. As the designated staff authority for the agency, my primary mandate is to ensure that all leadership, development, and training initiatives directly meet the needs of the Commission. Go to the next slide. To accomplish this, I act as an internal consultant. Instead of defaulting to time-intensive classes, I focus on creating learning pathways, developing individual and team training plans, and using proven adult learning best practices. My ultimate goal is to enable our subject matter experts and scale those solutions across the Commission. Because these agency initiatives require strategic development of our personnel, I am highly focused on measuring our success. And I'm continually evaluating if our program are actually meeting the needs of the Commission and measuring how employees apply these new skills on the job so I can provide a definite return on investment to the agency. Okay. These are the three things that I want to talk about a little bit today: the leadership excellence, looking at strategic gap analysis and equitable alignment. First, we'll start with leadership excellence. Next slide, please. I focus on building cohesive mission-aligned leadership pipelines at every level of the Commission. My strategy is to ensure our training is highly tailored to the unique realities of our agencies. In our Emerging Leaders program, Paige and Cassie are currently wrapping up the pilot year of the Emerging Leaders program, which will culminate in a graduation ceremony and a video montage presentation at the June all hands meeting. I look forward to joining this program and leading the next cohort with Paige starting in June. Our supervisor and manager program, I am deploying our formal DDI curriculum, but I am deliberately adapting this so it doesn't feel like this generic corporate seminar. I translate the materials to speak the language of government and to ensure the scenarios resonate equally with our field team and our in-office staff. This tailored approach is working. Our recent training scores improved from a 3.75 to a 4, and I look forward to more improvement in the future. Furthermore, to secure frontline buy-in for the 2027 curriculum, I will be hosting focus groups with supervisors, managers this fall to ask what they need and not just imposing a top-down training curriculum. Let's move on to strategic gap analysis. By proactively seeking feedback and analyzing our current resources, I am identifying and addressing critical gaps in our organization's capabilities rather than simply waiting for training requests to come to us. For example, we currently have a field safety training initiative. We launched a mandatory agency-wide baseline safety survey to all 13 managers and chosen supervisors to accurately assess field exposure, current practices, and budgets. Our current goal is to synthesize this data into a formal training design plan and actively advocate for centralized commission-wide safety funding to the executive leadership team. Instead of each unit having a homegrown system, we recognize this as a massive opportunity. We are now partnering with field operations to formalize, vet, and scale this valuable institutional knowledge and best practices so the entire commission can benefit. Training gap diagnostics. We also apply this gap analysis approach to the team dynamics and culture. Instead of just deploying a generic training class, we consult with state agencies such as CSAP. Our answer isn't always a training class. We want to fit the solution to the problem, be it documentation, a process, or maybe just digging deeper to find out what the core problem is. Let's talk about equitable alignment for a minute. Historically, our professional development has been somewhat siloed, with different units building their own redundant training tools. To ensure uniform, high-quality development across all units, I'm utilizing our centralized intake process that Michelle referenced earlier to process and evaluate requests and deploy standardized agency-wide solutions instead of one-off departmental solutions. This proactive approach also helps with accessibility and compliance. A foundational part of equitable curriculum is ensuring our materials are usable by absolutely everybody. We are currently coordinating 5 vendor-led PDF accessibility classes for 60 of our employees to establish a baseline of compliance. We're also working on the onboarding and the new hire experience. Equitable alignment also means ensuring every new employee gets the exact same high-quality foundational knowledge. I'm currently working with Hannah Hickam on a 6 to 8 month project to examine our new hire onboarding. We are also working to embed mandatory safety awareness section directly into the baseline onboarding checklist. Finally, alignment also applies to our financial resources. By governing the $500,000 Workforce Development Fund through a strict centralized workflow, I ensure that the training funds are distributed fairly. Whether it's an employee using their $1,200 individual allotment or units tapping into a specific group funds, we are guaranteeing that every single unit has the exact same barrier-free access to professional development. Let's talk about that Workforce Development Fund for a minute. Historically, our professional development has been, I want to give you a quick update on the $500,000 Workforce Development Fund that the Commission approved for us this past fall. What you really need to know is that the fund is officially up and running. We've hired the necessary staff to help execute it. We are already making great progress with about 10% of our workforce actively utilizing these funds for their professional development. Because we are managing a $500,000 investment, my focus is heavily involved with how we assess the value and measure the success of the program. Instead of just tracking attendance, we are evaluating how employees are actually applying these new skills on the job to help prove a definitive return on investment for the agency. And with that, I'll kick it back to Michelle.
Thank you, Dan. So I'm going to move on to, or I'm going to talk about engagement and culture building. So a lot of the things that Dan just talked about is really, really important. And it's been a really phenomenal experience with him as we've really learned to build or as we've learned, or as we built those relationships through ECMC staff and having these requests come in for these projects when gaps and needs are identified. So, we are also going to continue to build on that. And so these are some of the things that we already are doing. So we do have a lunch and learn program. We have one program where we bring outside speakers in that is more of for learning about cultures and things along those lines. And then the other one that we have is internal, and we have some of our SMEs come and speak to us. And as you can see here, there's one about stormwater, and then we had another one about the drones that we use. So we also have in building the culture and engagement, we have the employee awards, which employee awards will be coming up at our next at our upcoming all hands in June. And then, of course, we do assist with all hands. And the other thing that we're really looking or is for special projects as requested. So we do have SMEs, and our SMEs on my team are always available to help, and are called on to help with new things as we continue to build the culture and add new things. For instance, Hannah Hickam was asked to consult on a new committee that was being formed for AI use. So that is one of the many ways that we continue to work with ECMC. So, and as you can see here, these are some of the internal communications channels that we use. One is the intranet that was recently launched last October. And then the other thing that we have is the internal employee newsletter, and we're working also to add other channels for communication too. So what we do also is we track open rates on our emails, and we're also evaluating the intranet usage as well. And so we've already been making some changes and upgrades on the intranet to ensure that it is a usable space for ECMC staff. So looking forward. We will continue to expand training and expand organizational development opportunities as needed. We are also working to expand shared services, and so that may be with planning, with proposals, just really working to address gaps and needs as they are identified and brought to our attention. We are working on branding as well. So we do have a few new templates that we've been rolling out to ECMC staff, including a new presentation template. And then we also have others coming soon as well. And then, of course, we are focusing and working on accessibility, and we're going to continue to expand and with the addition of our new employee list and work on more of our digital asset management. So to make sure that we are meeting our regulatory requirements. So I hope that this has been informative and helpful for you guys, for the commission. And I have this time now to answer any of your questions.
Thank you very much for the presentation. Commissioners, questions? But generally, when we don't have questions, that meant the presenter did a really good job of presenting the information.
Well, thank you.
Thank you
I
very
think
much.
I was really, really nervous, and I apologize. I apologize for my nerves, but thank you for
No,
your
you got it.
patience.
It was great. Really proud to see the new unit and meet Mr. Vigil and all the members of your team. So congrats, go forward, keep going, do
Thank
well.
you. reach out to us. So if you need anything, we'll be happy to help.
All right, sounds great. Hearings Manager Thomas, let's take maybe 5 minutes and get the next OGDP up and running, and then we'll return at 11. Oh, it's 11:09, so 11:15. All right, as we're waiting for commissioners to get back to the hearing, let's go ahead and call the docket, get entries of appearance, and swear in witnesses. This is docket 250600109. Ms. Jost?
Yes, good morning, Chair. Jamie Jost of Jost Synergy Law for Crestone Peak Resources Operating LLC. And I also have all of our witnesses ready to be sworn in when you are.
All right, then let's go ahead and have all the witnesses elevate themselves and visualize themselves. And we'll have Assistant Attorney General Benjamin Boudreaux swear in witnesses. Thank you.
Thank you, Mr. Chair. I'll ask all the witnesses to be visualized. When I call your name, raise your hand, state your first and last name, and swear to tell the truth. Dan Harrington.
I, Dan Harrington, swear to tell the truth.
Jeff Annabelle.
I, Jeff Annabelle, swear to tell the truth.
Scott Farkas.
I, Scott Farkas, swear to tell the truth.
Aaron sorry, I'm going to get this wrong. Schlebaugh.
I, Aaron Slabaugh, swear to tell the truth.
Mary East.
I, Mary East, swear to tell the truth.
Lila Hooning.
Lila Hooning, I swear to tell the truth.
Did I get everyone, Miss Jost?
Yes, you did. Thank you.
Thank you.
All right, thank you. Then we'll now take up this docket, which is an oil and gas development plan. Ms. Jost, I would note for the record that we had public comment regarding this docket earlier at the hearing today. Those public comments will be interwoven into the hearing transcript, and assume that you and your clients were able to listen in so that you got a sense of the public comment that we received.
Yes, Chair, we did. Thank you. And thanks for the clarification about making it part of the record.
Yep. Okay. All right. The video panel is yours.
Great. Thank you. I'm going to go ahead and share my screen. Chair, are you seeing that from the full PowerPoint?
Yep. And it's in presentation mode, so you're in good shape.
Wonderful. Thank you so much. All right. Well, good morning, commissioners, staff, council, and members of the public. My name is Jamie Jost of Jost Synergy Law, and along with my partner, Kelsey Wozelinski, we represent Crestone Peak Resources Operating LLC on the State Blanca OGDP application before you today in this docket number 2506-00109. Crestone would like to thank the ECMC staff and the director for their efforts on this OGDP and Arapahoe County for its progression of the State Blanca permit through the local permitting process. Crestone respectfully requests that the Commission approve the approximate 3,883.1 acre State Blanca OGDP for up to 18 new horizontal wells to be developed from one new oil and gas location, and to also approve the corresponding Form 2A and joint and spacing unit application. This application was filed for lands within the 32,000 acre Rule 314 Lowry Ranch Comprehensive Area Plan boundary and is subject to Lowry Ranch Cap Order number 535-1490. The State Blanca oil and gas location is over 1 mile from any residential building unit, high occupancy building unit, school, and child care center. Although the proposed location is within a disproportionately impacted community, there are 0 residential building units within 1 mile. No Rule 304B alternative location analysis criteria applied, so no ALA was required. Crestone has applied numerous best management practices and enhanced systems and practices to the State Blanca location, as you will hear today, and has consulted with CDPHE, CPW, and Arapahoe County. The State Blanca OGDP is compliant and is an approvable application and will protect and minimize adverse impacts to public health, safety, and welfare, the environment, and wildlife resources, and will protect against adverse environmental impacts on any air, water, soil, or biological resource in compliance with Colorado Revised Statute 3460-106 2.5a. The State Blanca OGDP application was filed on June 17th, 2025, and was noticed on March 2nd, 2026. Crestone complied with all notice and publication requirements for this OGDP, and no petitions were filed. There were various public comments presented at the April 7th, 2025 511 hearing, many of which attended the hearing this morning as well. And Crestone will address those 511 public comments during today's presentation as requested by Chair Robbins during a prior hearing. At the conclusion of this presentation, Crestone respectfully requests that this commission approve the approximate 3,883.1 acre OGDP for the development of 18 new horizontal wells within the 2 proposed drilling and spacing units for the application lands. Provide that the 18 new wells will be located on 1 location within the application lands, and approve the associated Form 2A for the State Blanca West pad. To approve the requested relief in Exhibit C, Crestone's associated drilling and spacing unit application, and also find that the State Blanca West OGDP will protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and is in compliance with CRS 3460-1062.5A. Mr. Dan Harrington will now present Crestone's State Blanca OGDP today, and we'll have a panel of subject matter experts join us at the end for commissioner questions. Thank you, and we look forward to presenting to you this morning.
Thank you, Ms. Jost, and good morning, commissioners. We appreciate the opportunity to present SM's proposed State Blanca West OGDP today. State Blanca is the 5th of the anticipated 7 Lowry Ranch cap pad sites to be brought before the ECMC. It's planned to be an 18-well pad located in Arapahoe County, just off Quincy Avenue. City of Aurora is a proximate local government. SM has consulted with both CDPHE and CPW on this location, which has an EnviroScreen score of 17.33. This OGDP also includes 1 legacy pad site, the State Harvard 1H, just off the development area to the east. Produced water will be piped from the new State Blanca pad to the site for takeaway. This pad is designed to develop 2 DSUs, 1 east and 1 west. And here are those 2 DSUs, one 1,600 acres and the other 2,280 acres. The eastern DSU is entirely state minerals, while the western DSU is a mix of fee and federal minerals. These are all planned for development of the Niobrara Formation. There are relatively few existing wells in the development area. 1, an SM-operated horizontal, the State Harvard 1H, will continue to produce. Of the 2 legacy vertical wells, 1 was re-entered and replugged in 2025, and the other will require an OWE analysis during the Form 2 process. SM is proposing 2 phases of development here. The first phase will begin with pad construction in Q3 2027, followed by drilling and completions in late 2027 and early 2028. And the second phase of drilling will begin in late 2028 to conclude in early 2029. Next, we'd like to review siting. While the proposed State Blanca West site is in DIC, it is over 1 mile from the nearest RBU or childcare center. The site was positioned to avoid the mule deer HPH, here shown in purple, and the pronghorn HPH in green in this area. And while the access road partially overlaps mule deer HPH, the majority of that road is already in use to service the nearby solar farm. SM will also construct a portion of access road within HPH outside of season. The site is located downgrading to the Aurora Reservoir, eligible for a 3,000-foot setback per Arapahoe County regulations, and it does meet that setback. The site is also located over 2,000 feet from the city DOAA in the area. No ALA criteria were triggered, and CDPHE has reviewed the proposed BMPs and supports their incorporation. As we stated, Arapahoe County is the relevant local government. Crestone submitted its Arapahoe County permit in September 2025 after pre-app and neighborhood meetings, and submitted what is anticipated to be the final submittal materials last month. No major issues have been identified, and in the last week, we received notice that the county has moved Blanca to its final public review period, which ends June 10th, which is the penultimate step to approval. The City of Aurora is a proximate local government and reviewed the State Blanca siting upon consultation in 2024, specific to its proximity to the city DOAA and the Binney Water Treatment Facility. Ultimately, the city granted Crestone's request for a less than 3,000 foot but greater than 2,000 foot setback from the city DOAA and registered no concerns with the location. Next, we'd like to overview community interface. It's important to note that Blanca is very remote relative to housing, over 2 miles from the closest City of Aurora neighborhood and over 1 mile from any RBU at all. Crestone conducted extensive community outreach related to the Blanca site, including a CAP neighborhood meeting, a Blanca-specific Arapahoe County neighborhood meeting, in addition to the ECMC hosted 511 hearing. 12 public comments were received as part of this OGDP, and Crestone provided a summary to the ECMC. This OGDP was not petitioned. Here are the summaries of those comments and responses, and while I won't read through them specifically, we'll do a quick overview here. They focused on health and safety, proximity, wildlife, air and water impacts. There are also concerns about nuisances associated with the site, as well as climate change. And finally, spills, fire risk, and induced seismicity. We have addressed each of these concerns and are confident that our application is protective on all these fronts. Next, we'll review cumulative impacts and BMPs. This site will utilize the required enhanced systems and practices as a DIC location. There is no practicability assessment required for this site because we have adopted all required ESPs for DICs. On siting, we are outside HPH and over a mile from any RBU or childcare center. We utilize a substantial portion of existing access road and will construct or improve that part of access road within HPH outside of season. We've located the site near a solar farm and as close to Quincy Avenue as possible to reduce habitat fragmentation. All traffic will route eastward away from the site and away from Aurora neighborhoods. During the drilling phase, we will comply with the CAP commitment to a utility-powered rig. Excel has already designed and we have paid for the utility upgrade to the Blanca site. We'll also utilize Group 3 drilling mud and 32-foot sound walls for the entirety of the operation. For completions, we will continue to utilize the same sound walls. Frac water will be routed to the site via lay flat water lines, and a Tier 4 quiet fleet will be used for the operation. During production, oil, gas, and produced water will be transported away from the Blanca site via pipeline. We will also install a state-of-the-art tankless facility with a bulk separator 3-phase meter system that reduces the facility footprint. The facility will also be powered by utility power. Thank you for hearing from us on this application. With that, we would request approval of the State Blanca West OGDP for 18 new wells and 2 DSUs, and a finding the application protects, minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources. And with that, I'll turn it back to Ms. Jost.
Ms. Jost, you're muted.
My apologies, Chair. I was just going to say thank you, Commissioners, for your consideration of this application today. With that, I'd like to ask all of our subject matter panel experts to come on screen, and everyone is available for any questions the Commissioners may have.
All right. One question. We had a fair amount of public comment this morning. Does the applicant desire to address the public comment?
Chair, I will look to Mr. Harrington or any others, but I believe many of the comments were also brought up in the 511 hearing. Some were almost the same. And so those have been addressed in the submission to the ECMC staff, addressing the 511 hearing comments, as well as other basically portions of our presentation today that address the OGDP itself. Mr. Harrington, anything else to add?
I will just add, if we want to go back to slide 9, this site is really quite remote relative to majority of the negative public commenters we heard from. We're very confident that the impact will be extremely minimal on the neighborhood. If the chair would like, we can go through the public comment response slides in more detail. If
Please do.
Okay, very good. Again, we are For health and safety impacts, we are compliant with all residential business unit setback requirements, both county and state, far exceeding those setback requirements. So distance does matter, as we heard in several hearings. We have our enhanced system and practices to further protect the community. I'll skip over general opposition to oil and gas. But on the environmental impacts and wildlife, we are near 2 high priority habitats, but we are outside them. We consulted extensively with CPW, who does not object to this application. And we are doing the small amount of construction we need to do within HPH outside the season. As to air quality, again, we have no receptors nearby. We have fully grid-powered drilling. We have a Tier 4 completions fleet coming in. We have a tankless design for the facility, and we have 3-phase takeaway from the site itself. As to water usage, fresh water for the OGDP is sourced through existing surface water contracts designed for industrial and agricultural purposes, not drinking water. None of the frac water for this site will come from Aurora Reservoir. It routes from pretty far to the north, and we're transporting it via a lay flat pipeline, which is obviously an advantage on a traffic front.
Mr. Harrington,
Sir.
Public commenter Nathan Lyon had specifics on wildlife protections and your inability to meet specific setbacks. Can you comment to that, please?
The setback, I would say that we have avoided the HPH quite intentionally here, and the pad surface itself does not specifically impact any wildlife we're of concern of. I'll add further, the sound walls do provide sound isolation to the nearby HPH to reduce impacts there. Lastly, I'll add that this siting is pretty close to a major artery, Quincy Avenue. So this is not really a completely isolated area for wildlife as well. If anyone from my team on the wildlife side would like to come on and add further comments, I'd invite them to do so.
Just looking around to see if anyone else had thoughts on that.
I can just chime in and say that I would agree with the comments Dan just made. We're outside HPH. We've consulted with CPW extensively regarding both HPH and other wildlife habitats in the area. And so we have several BOPs in place. If there was something more specific in his comment that I may have missed, I'd be happy to try to address it. But that was my understanding of his comment.
And Chair, if I may, Mr. Lyon's comment was addressing, he called it the Pronghorn Natural Area. That's a county open space. That's the name of the area, but it, again, from the perspective of the OGDP, the ECMC rules, and CPW's high priority habitat area, these are outside of that. So Mr. Lyon's comments were addressing a county open space and not a CPW comment.
And can you talk to me a little bit about the CPW consultation and where that ended up?
Ms. Huning, could you address that, please?
Sure, I'd be happy to. So we had consultations beginning, field consultations beginning in 2022. So we visited the location with CPW staff. We returned, I believe it was in 2024, excuse me, for a second field consultation where they looked more closely at the access road going through HPH. We had several email back and forth meetings and various correspondence throughout the preparation of the wildlife mitigation plan and OGDP preparation process. And then we had a final post-completeness consultation with them as well, just before the submittal of CPW's consultation summary. So we've addressed all of their concerns, the biggest one being constructing the access road section in HPH outside the mule deer wintering season, which we've committed to, as well as a few other wildlife BMPs we've also addressed with them. So I think their summary nicely captures a lot of the key points that were discussed, but it was a combination of multiple consultations in the field and virtually. I hope that answers your questions, Chair. Please let me know if I can further clarify.
Thank you. We also had several commenters quote Rule 307. That is a general rule that even if you meet rules, you still need to be protective. and allows for denial if you're not protective. Does the applicant desire to speak to that comment that was a refrain that we heard quite a bit?
Chair, I'm happy to address this. From our perspective, this OGDP, the State Blanca West, not only is it under the Lowry Ranch Cap Order 535-1490, which provides comprehensive area plans, protections, and requirements for this location, but it does not only meet all of the rules, but it exceeds the rules. As Mr. Harrington testified to, it actually applies every enhanced systems and practice in Rule 316. For a DIC community or not for a DIC community. And so from the aspect of utilizing Rule 307 and your review of the protective nature of this OGDP, Crestone not only has met the rules, is compliant with the rules, but also exceeds the rules for this. So we believe this is an approvable application under the rules and the statute.
Further questions for the applicant? Commissioner Messner?
Thank you, Mr. Chair. Along the same lines, as far as addressing some of the comments that we heard today, could you talk a little bit about produced water disposal and the difference between produced water in the DJ Basin and the referenced produced water associated with operations in Oklahoma, and what would be the anticipated mechanism for disposal here, and any other differences to address that comment?
Absolutely. I can happily address that. So like all Lowry Ranch Cap pads, there is no proximate industrial injection facility nearby, nor can we really permit one, right? So ultimately, the water produced from the Blanca site will be trucked to injection facilities in Weld County. However, we are installing a produced water takeaway system to do the first several miles of transportation via pipeline to reduce any impacts of traffic as far west as the Blanca pad site. So that's step one. Once that water reaches the offtake site, it will be loaded onto trucks and brought up to a commercial water disposal facility, just like every other horizontal DJ Niobrara well in the DJ. If there is concern about seismicity, again, the tectonic stresses in Oklahoma are very different than those in Colorado. We've been injecting wastewater here for decades and have seen very minimal seismic activity associated with that, and no destructive seismic activity.
Can you talk a little bit about the volume of produced water and operations in Oklahoma versus the volume of produced water in the DJ Basin?
I'm not specifically knowledgeable as to the amount of water that comes out of horizontal development wells in Oklahoma. What I can say is that the Niobrara Formation in Colorado produces the bulk of its produced water in the first year. The majority of it is actually water that originally went in with a frac, and it tapers off very dramatically. We usually see produced water volumes drop by a factor of 10 over the course of the first year. So you get a pulse up front and then it drops off quickly.
Okay, thanks for that. There was also public comments associated with the Gallatin incident and uncontrolled well blowout. Can you explain the protective measures that you intend to put in place to ensure that an incident like that wouldn't occur?
Absolutely. Ms. Jost, do you want to start with this one?
Yeah, I'm happy to. And Commissioner Messner, I mean, recognizing that's a different operator as well. They're Crestone and with SM, they will be in compliance with all of the ECMC rules relating to their operations, their downhole operations, as well as their surface operations. That carries through to any other federal regulations that apply as well. All of that would be covered as part of their plans that were submitted with the Form 2A. Again, that have been reviewed by staff and has been part of the director's recommendation for approval of this OGDP. So those protective measures that are required by ECMC's regulations have been built into this oil and gas development plan proposal and will carry through for their permits and their operations.
Okay, thank you. Um, I think that's the questions I have right now. Thank you.
Thank you.
Thank you.
Further questions from the commission? Commissioner Cross?
Thank you, Mr. Chair, and thank you for the presentation. I wanted to ask a quick clarifying question. So, in your, I apologize, in your section on the proposed timelines, you specifically note 2 phases. Both those phases, even though being done with electric drilling, both those phases are occurring outside the ozone season, correct?
That is correct.
Okay. And then I also wanted to ask about Chair Robbins brought up some of the public comments, specifically by Mr. Lyon for one. He had also mentioned the proximity to other receptors, not just RBUs and wildlife, but I think he also mentioned the proximity to roads. Did you have any specific comments on that?
Well, the Blanca site is located relatively close to Quincy Avenue. I can give you a specific measurement here in a moment, but we actually view that as an advantage, right? Because the closer we are to the avenue, it's about a third of the mile from Quincy Avenue. Staying close to that, which again is a pretty major industrial road, does allow us to concentrate operations close to that area and not fragment wildlife habitat to the south. And it also allows for a shorter access road build and a slightly shorter traffic route. So we don't see proximity to the road to be a negative here.
Are you aware of any studies or anything talking about detrimental health impacts to people driving on roads nearby?
I'm not aware of anything like that.
Okay. Thank you. Those are my only questions.
Thank you.
Further questions from the commission to the applicant? All right, I'm not seeing further questions. Thanks to the applicant for the presentation. Thanks to staff for the work here as well. If we could unvisualize all the witnesses, it will return it to the commission for deliberations. Commission deliberations. Commissioner Messner.
Thank you, Mr. Chair. So I'll start with the application itself, and then I'll go through and make some of my deliberative thoughts on both the application and the public comments that were provided as part of this application. I think that this particular application, some of the things that jumped out at me is that it's 1 mile away from any individual residential building unit. It's over 2 miles away, 2.5 miles away from the nearest neighborhood. It's over 1 mile away from any schools, childcare centers, or high occupancy building units. I think that all of the enhanced systems and practices, and so I think important to note that the enhanced systems and practices were required to be applied in our rules through statute. And those enhanced systems and practices were the best management practices that could be implemented to ensure minimizing and mitigating and avoiding impacts to both disproportionately impacted communities and non-disproportionately impacted communities in the ozone non-attainment area within the Front Range. These are the best technologies that are available. They're the best practices that are available. And to my knowledge, this is the first application that has applied every single one of the enhanced systems and practices without asking for a practicability assessment or a waiver from one of the enhanced systems and practices. In addition to that, all of the operations that are being proposed here, at least the pre-production operations, are anticipated to be done or are scheduled to be done outside of the ozone non-attainment season. They are utilizing an industrial water right that is associated with this application. I note that the City of Aurora has written a letter of support for this application and is also the water right holder for the City of Aurora's reservoir, the Aurora Reservoir. And that this development has cited 18 horizontal wells. Quite a ways away from any particular sensitive receptors. And the advantage of the horizontal well infrastructure in general is to minimize surface disturbance versus legacy well development, which would historically have occurred in this area, which puts significantly more wells significantly closer to residential areas. And has significantly more surface disturbance than the technology that's being employed here with horizontal development and longer laterals. There was a number of comments today, both written comments, well, not just today, but in the 511 hearing. And I want to talk a little bit about some of the comments and my deliberative thoughts on that. There was a lot of discussion about public health studies and setbacks and distances away and cumulative impacts. And I've made these comments before, not only in hearings within this area, but hearings in general. But I do take my role as a commissioner and my responsibility to ensure the protection of public health, safety, the environment and wildlife resources incredibly seriously. And so I have evaluated hundreds of public health studies in the course of the 6 years that I've been involved as a commissioner. And I've not found any non-biased study that indicates that the setbacks located within the rules do not develop a protective setback. You know, there have been studies presented and studies that I have read, both in the development of the rules and in applications since the rules, that there may not be any setback necessary. That seems nonsensical to me, and that there's studies that state that 15 miles is not a big enough setback. And I think that's nonsensical as well. I think that there's a lot of information out there on different setbacks, and I think there's a lot of information about how the different constituents that we would be concerned about regarding setbacks do dissipate over a certain amount of distance to a point that it is protective of public health, safety, welfare, the environment, and wildlife resources. I think cherry picking any one individual study, to make determinations on any application is not utilizing good judgment. I think analyzing the breadth of information that's provided, which has been done a number of times in evaluating applications and in promulgating the rules as required by Senate Bill 19181, is what's been done. And I think we continue to evaluate the public health studies that come out as they come out, both as individual commissioners and as a commission itself. I continue to believe that after reviewing the hundreds of studies that I've reviewed over the last 6+ years, that the setbacks within the rules are appropriate if applied correctly. And I look at this particular application where we're talking about locations that are a mile away from any individual OGDP and 2.1 miles away from any residential areas. And note that sometimes those are 2.5 to 3 times further than the setbacks that are in our rules. And so I find that to be an appropriate setback away from residential building units. I think there's been testimony regarding violations of the chemical disclosure laws. These violations have been documented and enforcement is ongoing. And I think applying any consideration of this issue and the application before us creates legal issues. I think the same goes for the arguments associated with falsification of environmental data associated with operations not associated with this application. And so would think the same about that. I appreciate the comments from the state representatives that were presented today. The statute developed by the legislative bodies are what our rules are based on. If there is a belief by the individual representatives that the statute needs to be adjusted, then I encourage that to occur within the legislative process. This commission is directed and guided by the statute that the legislature develops, and our rules reflect that. I think the Gallatin incident and the impacts associated with that are a real concern. And I think that the distances and setbacks associated with this particular application and the requirements that have been put forth by ECMC as a result of that incident make me comfortable that that issue is addressed to the best of our ability. Rule 307 was a big topic in public comments. Rule 307 can and has been utilized in OGDP applications. I've utilized Rule 307 a number of times in applications. Rule 307 is not a blanket ability to deny an application in an arbitrary and capricious way, but rather to evaluate an application and make a determination, and utilizing good judgment and reasonable and necessary analysis that an application is not protective. I do note that in this particular application, with the location and the setbacks that have been presented in this application are significantly further away than locations that Save the Aurora Reservoir proposed in the previous application before us, which were much closer to residential building units, but were deemed to be protective by Save the Aurora Reservoir in their analysis. And so I'm not sure how the application of Rule 307 in this particular application would be a reasonable or necessary application of that particular rule. There were a lot of comments about air quality. I talked about enhanced systems and practices and the importance of those. I've mentioned that the application is proposing operations, pre-production operations outside of the ozone non-attainment season. I would also suggest that it's important to do an evaluation of the state's greenhouse gas reduction roadmap, where it clearly indicates the sectors that are driving the front range ozone issues and shows the targets and results of efforts towards those reductions. It also shows that the oil and gas sector and the associated regulatory structure that both ECMC and CDPHE have put in place are shown to meet and exceed the targets, while other sectors, including passenger car transportation, has not, and is an increasing driver of the increased emissions that we're seeing in the ozone non-attainment area in the Front Range. I think cumulative impacts was a big topic as well, and is a really important topic for me. And in fact, I think you've heard me on a number of occasions push operators and applications and fully evaluating cumulative impacts. I've read the cumulative impacts analysis that was provided as part of this application per Rule 319, understanding that it was a different rule set that this one was under. I do find that even with the previously approved oil and gas development plans in this area, because of the environmental or EnviroScreen score of this particular area, the minimal legacy wells that are associated with this particular area, and the consolidation of operations and minimization of surface impact associated with these new operations, that I am not concerned about the cumulative impacts associated with this particular application. I think water is a significant consideration, particularly in this year, and was also a part of a lot of the public comments that were provided today and in the past. I think as we look at water in general in the state of Colorado, I'm continually disappointed that we're not seeing more reuse and recycling of produced water in operations and new OGDPs. In fact, it takes a regulatory requirement to see, I'm afraid, any reuse and recycling of produced water in new oil and gas operations in the DJ Basin. Having said that, the water that is being utilized in that area for domestic use is often sourced on the western slope and is brought over here in a buy and dry type of situation in order to be able to feed the growing subdivisions in the Denver Metro Front Range, to the detriment of other water users that are on the other side of the state. I also acknowledge that each entity that is utilizing these water has a water right associated with it. And so the city of Aurora has a water right to the water that it sources from the western slope of Colorado. And this particular operator has a water right associated with an industrial use for oil and gas operations. And so those water rights are the way that the state manages water on a seniority and priority basis. And City of Aurora has its water rights, and this operator has its water rights for the use that it is intending. I think that the high priority habitat question has been addressed, and I think there's other commissioners that will speak to that. I think there was some comments associated with why we apply the rules that were in place when a permit is applied for. That's state law. I will note that CDPHE is this commission's public health expert and has provided comment on this particular application and has indicated that they feel that the application does protect public health, safety, welfare. I indicated before that I have fully considered the public health, safety, welfare, environment, and wildlife resources associated with this particular application, and am comfortable with the application as presented. And so would be in support of this application.
Thank you, Commissioner Messner, for the comments. Commissioner Cross?
Thank you, Chair, and thank you, Commissioner Messner, for leading off. I'll try to be brief, especially as many of my comments you addressed already. I think just a couple quick points. I also am highly supportive of many of the BMPs and ESPs being used here, CDPHE support, CPW support, and the work done in those consultations. I did want to specifically address a few of the comments that came up. First of all, I think that as Chair Robbins went into in some of the questions with the operator, Rule 307 seemed to be the rule that everyone was trying to try and comment on with respect to suggestions as to why this should be denied as an application. As Chair Robbins indicated, 307 is kind of a baseline rule. You can approve, you can deny, you can stay. And ultimately, as I'm looking at this, because of those BMPs, because of the ESPs, I do think that this is protective. And so therefore, I do think it is approvable under 307. One additional thing that stuck out, and the part of the reason I asked about it is the two phases for the operations here. I think that sometimes we go back and forth on the appropriateness of the multiple phases. And even with the electric drilling, I do think that trying to make sure that all the work is being done outside the ozone season is especially notable in this instance, given that it is in the Front Range, given that there's going to be trucks going, there's going to be other equipment besides just the electric drilling rig. I think making sure that it's done outside the ozone season is important. And not just outside the ozone season, but also making sure that construction of it is going to be done outside the high priority habitat timing limitations that the access road is going to go through. So I think that's important as well. With respect to a couple of the comments, I did want to, first of all, clarify. One of the commenters specifically said that I suggested we had to approve Sunlight Long because we've approved prior applications, and we had to approve it because otherwise we'd have to go back and look at all our prior applications. That is not why I voted to approve Sunlight Long. I voted to approve Sunlight Long, but because I believe under our rules and under all the information provided, I do think it was protective of public health, environment, welfare, wildlife resources, and the environment. And I want to make sure that everyone's aware that my references to prior applications is to say, if we were to find that something that was more than 3,000 feet away was not protective because of proximity, it calls into question all the prior applications we had approved that were within 3,000 feet, within 2,000 feet. And so I do think that's an important clarification. I don't think those prior decisions bound us at all. But I do think it would have called into question our prior approvals as well. And I also wanted to make one comment about one of the commenters specifically noted that read the writing on the walls, renewables are coming, oil and gas is dying. I agree. I 100% agree that we are in an energy transition. I support us being in an energy transition. But as has been said many times before, it's not simple as turning off a light switch and you make that switch to renewables. And more importantly, our job on this commission is not to make policy decisions with respect to what energy sources should be used, what energy sources should be sought after. Our job is to specifically look at the applications before us and determine if they do meet the rules, including whether they're protective. And so it's not a matter of prioritizing other sources of energy, other options. It's instead looking at, are the applications before us protective? And so I think that's important to note as well. And then the other thing I'll quickly note on, and I appreciate Commissioner Messner bringing this up as well. Given the 2.5 miles plus distance from the neighborhood here, as Commissioner Messner mentioned, I do think this is notable given that during the Sunlight Long application, they specifically pointed out the stars ALA number 4 and ALA number 1, number 4, and number 5. And those were all 1.5, 1.4 miles away from the neighborhoods as well. But all those locations they said would be much more protective. And so the fact that this one adds another mile away from those neighborhoods, I think is very significant. But for those reasons, I do agree. I do think that this application is approvable and I will be voting in favor.
Further deliberative comments from the commission? Commissioner Oath?
Thanks, Mr. Chair, and thanks to my fellow commissioners for very thoroughly sharing kind of your thoughts and analysis on the application and the comments that we have received. Given that, I was planning to go through all that, but I will just kind of touch on or reiterate a couple of points. One is I did just want to provide a comment about with respect to the report that we have convened a panel to review regarding the recent health studies and the comments that we heard suggesting that we should not act on this application until that report is issued and the commission has reviewed it. I think I just want to be very clear that the report from that panel, it does not by itself change our rules or determine or govern permit outcomes, right? It is a process and a report to help the commission and all of us, frankly, better understand 3 specific health studies so that we can, then discuss and determine what next steps may be warranted. So I just wanted to make that comment. And then I won't go through kind of each of the themes of public comments that I had in my notes and some thoughts based on that, because I think that has been addressed very thoroughly by my fellow commissioners already. But I do just want to share that, I have reviewed and considered all of the comments that were provided. When I consider public comments, I'm thinking about whether an issue has been raised that indicates that the application does not meet the legal requirements for the application. And in doing that, I consider the application materials, I consider our staff's analysis and the director's recommendation. I consider the consultation and expertise from our fellow agencies at CDPHE and Colorado Parks and Wildlife. If an issue has been raised that has not been thoroughly addressed, then I would agree the commission would be able to take action to address that issue. And that might mean a continuance to further analyze an issue. It may mean adding a condition. It may mean denying an application. And, when this type of circumstance has arisen, this commission can and has availed itself of all of these options, even quite recently. I just want to share and reiterate what I know my fellow commissioners also would say is that I do not take my decision on this application or on any application lightly. And I do agree that the commission has the authority to deny a permit application that does not meet the legal requirements, or to impose additional conditions, or to stay the matter for additional analysis in those circumstances. But in this case, I find that the application does meet our requirements. And that's all I was wanting to add. Thanks.
Thanks, Commissioner Oath. Further deliberative thoughts? Commissioner Ackerman?
Thanks, Mr. Chair. I'll give some final thoughts if you're going to add as well. And I just wanted to emphasize a couple of points here, and as probably anticipated, wanted to touch on wildlife just a little bit, but from the perspective of one of the assertions that the Commission's processes themselves, as established in regulation, don't lead to a thorough analysis. And so in so doing, I wanted to just take a quick example of CPW's consultative analysis and timeline as an example of how thorough ECMC's consultations are. And I'll make a couple of points on the wildlife concerns as I go, recognizing upfront that CPW is the state's recognized expert in wildlife management. And I won't go through the whole consultation. It's certainly in the record. If anyone wants to read it, it's in its entirety. I certainly have, as my fellow commissioners have pointed out. We review many materials as associated with each OGDP. And the CPW recommendation starts that CPW has approved the mitigation plan and doesn't have any further wildlife concerns. It mentions some of the issues that we've talked about today, that it's entirely outside of 1202C, 1202D, and 309E high priority habitats. And it does soundly address the 850 linear feet of the access road, which is located within Mule Deer Severe Winter Range, by a best management practice of not allowing the construction of that road during the timing limitations commonly associated with Mule Deer Severe Winter Range. A tried and true practice that CPW employs, not just with oil and gas development, with any other type of development on which it comments. CPW and the operator, as Ms. Hunholtz pointed out, were in communication for a number of years, and not just touching base, but detailed analysis of the points that were wildlife related in question here. There are several pages starting on September 27th, 2022, going through to April 1, 2024, April 29, 2025, and another 3 pages of point touching and issues and communication between the operator and CPW. CPW details the reasons for touching base and the analysis used, as well as the results of each step in the process. I wanted to specifically note, as CPW did, that the operator did previously move this location from the southwest in 2024. It was closer to Aurora Reservoir, and the Aurora's Binney Water Treatment Plant as originally proposed, but the operator through these discussions did move it farther away. And then it goes through the best management practices that CPW and the operator have worked out, even though it's outside of high priority habitat. Largely, there's a wildlife mitigation plan, and there are many best management practices in order to facilitate wildlife throughout the construction, construction, the drilling, the operation, and production of the facility. And in the end, CPW recognizes the efforts that are made by the operator. It mentions that the operator will install a full wrap 32-foot sound wall for the duration of all the development operations. It mentions, as was brought up, the siting of this location is near 3 other industrial facilities, solar facilities, and a third of a mile from Quincy Road, which helps keep wildlife habitat unfragmented. And it also talks about other species throughout the consultation process, including all those species that have been raised during the 511 hearing and in other written comments. And so I just don't want the public to get the impression that there's a phone call to CPW and CPW says, now what are you doing? Yeah, that's good. That's not how it works. It's significant, prolonged, and intensive, involved consultation from Colorado's world-renowned wildlife experts. And I have confidence in what they do, and I have confidence in their results of the review of this application. Now, that said, I just had another point or two I wanted to make, and I wanted to touch base on the assertion, as it came up a number of times on Rule 307, that we don't have to approve an application even if it meets duly and legally established standards. And I wanted to point out that administrative regulations, by their nature, are created to implement statutory mandates, and therefore their purpose is to take the statutory mission, in this case, that's coming up in this rule, and demonstrate how it's being implemented throughout compliance with the regulations. And I wanted to use, as I have before, a driver's license analogy. In Colorado, in order to get a driver's license, you have rules and regulations. You can't just start driving a car. You've got to gather the required documents, and those are proof of identity, proof of residency, name change, and a number of other things that all have sub-regulations associated with the applicability of those regulations. You've got to complete the prescribed education and training, and they're broken up into 3 categories. You've got to take the exams and obtain a permit. There's an application, pre-registration, there's a written test, vision test, and ultimately a permit issuance associated with a fee. And then you have to pass the driving test and have to provide certain requirements associated with that. Ultimately, the license is finalized once you've passed them all and brought your documents back to the DMV and paid the standard fee. And my question would be, what if a person met all of those requirements and the standards that are clearly set forth in regulation, and then they were denied a license for not complying with the broad mission of that agency? In this case, the mission of the Colorado Division of Motor Vehicles is to promote public safety, trust, and confidence for all Coloradans by delivering customer-centric driver's license and motor vehicle services. So to me, in this hypothetical analogy, which is pretty analogous, a person would be denied even if they passed all those requirements because ultimately the deciding official or officials decided that that person driving does not, quote, promote public safety, trust, and confidence, even though all of those rules have been put in place in order to promote those ideals. And I ask you, would that decision be justified? This is what, in my opinion, the opponents of this PAD are asking us to do. And driving in Colorado is not a light issue. There are around 700 vehicle fatalities in Colorado every year. To me, denial of this application, given the points that my fellow commissioners have brought up, would certainly not withstand any degree of judicial scrutiny and would be clearly arbitrary and capricious, in my opinion. I've mentioned before the judicial review standard that we consider frequently when we're looking at applications. And that is certainly an opportunity for a district court to review our decisions and decide whether they were done correctly or not. And in the end, we have to adhere to legally accepted practices and standards as we review these applications. And that's something, besides the points that my fellow commissioners have brought up, that's always on my mind. So to me, this all leads to the rules themselves are the point of discussion rather than a pad by pad assertion that each pad broadly doesn't meet the mission statement standards. And so we've talked about, do the rules need to be changed? Should there be to me, there clearly can't be a denial here. Should there be a stay? And specifically, it was noted that Commissioner Oath has convened a panel of experts on some of the studies that were touched on today, and I appreciate Commissioner Messner's points on health studies. That's certainly a point that we are all very studied on. Our stay rule in 307 that was pointed out is not a good basis for this kind of a stay. This panel of experts has been convened specifically to review 3 recently released public health studies looking at the risks associated with oil and gas development to help the Commission better understand what the studies do and do not find, and to help inform future discussions and next steps. They're not necessarily going to recommend rule changes. It certainly could result in rule changes if the Commission reviews their analysis and decides that that's warranted. And in the end, it's important to note that, as I think it was either Messner or Cross pointed out, that the Administrative Procedure Act requires that we apply the rules as they exist at the time of the application. So even if we stayed this application, the results of that public health study, if they do result in a rulemaking, would not apply retroactively to this application. As Commissioner Oath pointed out, the Commission has a number of times stayed applications for cause. And that's the intended utilization of Rule 307 as it relates to stays. In my opinion, there's simply no cause for a stay, and a denial does not meet the standard of judicial review that is required by legal practices and principles. I'll cut off there and not address any other points, and I really appreciate fellow commissioners. I don't have anything that differs from what they've said so far. Thanks, Mr. Chair.
Thank you, Commissioner Ackerman, and thank you to all 4 of my fellow commissioners for the thoughts here. And I guess it would just sort of put a conclusion on those thoughts. We're hearing more and more from residents who, appear outraged at our implementation of 181 and how we are applying our rules. I think the one thing that folks would all agree with, whether they like it or not, is we've been fairly consistent in how we've applied the rules that developed out of SB 19181 and all the other legislative prerogatives that were delivered to us, the cumulative impacts prerogative, the enhanced systems and practices. So, at the end of the day, we're doing our best in a tough job. We are attempting to implement and apply 181, the enhanced systems and practices, the cumulative impacts, and all the other legislative delegations that were delivered to us. And we're trying to do that consistently and in accordance with the Administrative Procedures Act. And I get it. If you folks that are not happy with how that's being implemented, go talk to Representative Ricks. Go talk to Representative Hamrick. Go talk to your legislators. We're doing what we believe we have been told to do. If we need to be told to do something different, go talk to the legislators. They're the ones that actually have the power and prerogative to, suggest that we need to be doing something differently. So, with that, I want to conclude by thanking all the members of the public for participating with us. Despite the fact that you're frustrated with us and that you're frustrated with the way that we're implementing things, we do appreciate everything you say. We take it to heart. We think through it. We apply the rules. And, it is something that we continue to, appreciate as we think through these things for the state of Colorado. So with that, I don't believe, AAG Boudreaux, if you could show up, I don't believe we have anything contingent here. And if that's not the case, then I would move approval of this OGDP.
That's correct, Mr. Chair. I didn't see any variance requests or COAs, so I would recommend a motion to approve the application as applied for.
So moved. Do we have a second?
Second.
Motion and a second. Is there further discussion on the motion? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? That motion carries. It's 12:19. Let's return at 1:15 and let's take a lunch break. Thanks. Okay, welcome back. It's the Energy and Carbon Management Commission June 3rd hearing. We are returning from a break. It is 1:15. We're taking up docket 251200262, an oil and gas development plan proposed by the applicant Laramie Energy. It is called, it's kind of a strange name, the 2025 CC 0797-06-07 OGDP. Ms. Wazelinski, welcome, and do you have your witnesses available for swearing in?
Thank you, Chair. We do. They're all here on the hearing. So if everyone could please turn their cameras on, we'll get you sworn in.
Thank you. I'll ask each of the witnesses to be visualized when I call your name. Please raise your hand, state your first and last name, and swear to tell the truth. Katie Middleton.
Katie Middleton, and I swear to tell the truth.
We cannot see you, Miss Middleton. It looks like there you are. Hi.
My name is Katie Middleton, and I swear to tell the truth.
Thank you. Hannah Eastwood.
Hannah Eastwood, I swear to tell the truth.
Kyle Gorinsky.
Kyle Gorinsky, I swear to tell the truth.
Austin Edge.
Austin Edge, I swear to tell the truth.
Edward Brodsky.
Edward Brodsky, I swear to tell the truth.
Aaron Duncan.
Aaron Duncan, I swear to tell the truth.
Thank you. Did I get everyone, Ms. Buzzlink?
You did. Thank you very much.
Thank you.
All right. The floor is yours. Go ahead.
Thank you, Chair. We've got a PowerPoint, so let's get that brought up, and then I'll get started. That looks great. Okay, well, good afternoon, commissioners. My name's Kelsey Wazelinski with Jost Energy Law, and with Jamie Jost, we represent Laramie Energy LLC in the 2025 CC 0797-0607 OGDP before you today in docket 2512-00262. We may refer to this OGDP as the 0607 in the presentation. We would like to thank Garfield County for its support of the 0607 OGDP and also ECMC staff and the director for their efforts on this OGDP. I'll take just a few minutes to summarize the 0607 OGDP and requested relief before I turn it over to Laramie. This OGDP requests that the Commission establish an approximate 4,146.2 acre OGDP for the development of 8 new horizontal wells in the Niobrara Formation in Garfield County to be developed from the amended expanded CC 0797-0607 pad. The 0607 location currently has 2 producing directional wells, which Laramie will plug and abandon prior to construction of the amended expanded location, so that the location is authorized for 8 new horizontal wells only. The OGDP also requests the establishment of 2 drilling and spacing units, an approximate 2,885.22 acre North DSU for the development of 4 horizontal wells in the Niobrara Formation, and an approximate 1,253.7 acre South DSU for the development of 4 horizontal wells in the Niobrara Formation. There are no residential building units within 1 mile of the proposed amended expanded location, and therefore a pre-application community meeting was not required. As Laramie will describe today, Laramie consulted with CPW due to the proposed amended location being within Aquatic Sportfish Management Waters HPH, the pipeline corridor intersecting with the elk winter concentration area, and the access road intersecting with the mule deer winter concentration area and mule deer severe winter range. Upon such consultation, CPW waived ALA due to the expansion of the existing pad causing less disturbance than an alternative location, the mapped aquatic sportfish management waters being ephemeral and exhibiting no ordinary high water mark, and the waters in question being not directly down gradient from the location. In addition to CPW, throughout the planning and OGDP process, Laramie consulted with Garfield County and the BLM, which Laramie will outline today. As a result of these consultations, Laramie has committed to several BMPs to avoid, minimize, and mitigate potential adverse impacts, which Laramie will also describe today. And finally, Laramie has complied with all notice requirements for the OGDP. No formal petitions were filed and no public comments were received on the Form 2A. With that, I will turn it over to Katie Middleton with Laramie to continue the presentation.
Thank you, Ms. Wazelinski. Next slide. Good afternoon, Chair Robbins and Commissioners. My name is Katie Middleton, Permitting Manager with Laramie Energy. We would like to thank the Commission for the opportunity to present the 2025 CC 0797-0607 OGDP today. Laramie would like to thank Garfield County, the BLM, CPW, and ECMC staff for their guidance and time with this project. Laramie is an exploration and development company that solely operates in western Colorado. Laramie's core operating areas are Cascade Creek and Plateau Valley, both located within the Piceance Basin. Next slide. Laramie has filed 2 drilling and spacing unit applications for the 8 proposed wells. DSU-1 is for the southern development and DSU-2 is for the northern development. The OGDP will target fee minerals. Next slide. This timeline lists key events of the project. Laramie began evaluation in the development in 2024. Throughout the preparation of the OGDP, multiple pre-application consultation meetings with regulatory agencies were conducted. No public comments were received and no formal petitions were filed. Next slide. During the presentation, I will refer to the location as the 0607. I'd like to take a moment to address one of the most frequently asked questions during this project. Is the OGDP named after the 6-7 trend? And the answer is no. The location was named nearly 2 decades ago, and the 6-7 reference is merely a coincidence. This oil and gas location is situated in Laramie's Cascade Creek operations area in Garfield County. The CC part of the OGDP stands for Cascade Creek. Laramie is proposing to drill 8 horizontal wells. There are 3 surface owners involved for the location, including Laramie. The working pad surface and the production pad surface will solely be located on Laramie's surface. Laramie has an established SUA for the disturbance on the other fee parcel. For the disturbances on federal service, Laramie submitted 3 standard Form 299s to the BLM. Next slide. The 0607 is situated in a rural remote area of Garfield County. The site is located 10 mapped miles north of the town of DeBeck. The nearest public crossroads are County Roads 213 and 204, which are located 3.8 mapped miles southwest of the 0607. Next slide. The rugged terrain surrounding the project area consists of steep mountainsides that rise approximately 2,000 feet in elevation to the top of the Room Plateau. The well pad is located near the concrete valley floor. There are no residential building units, high occupancy building units, school properties or facilities, childcare centers, or designated outdoor activity areas located within 1 mile of the proposed location. Next slide. The OGDP is situated within a disproportionately impacted community and was filed under EnviroScreen 2.0. As shown in the map before you, all of western Garfield County is designated as a DIC. This rural area is remote and consists of large public parcels and public lands. The subject DIC block is composed of 56% federal public lands. Formal consultation with CDP did not occur for this OGDP. The 0607 is in the attainment area. Laramie is currently not subject to NOx intensity requirements, and this location is not located within the ozone non-attainment area. Next slide. Prior to site selection, an environmental consultant conducted biological and surface water field surveys. Data from this field surveys were utilized in the design of the project to best avoid receptors. The nearest water feature to the site is Gilman Gulch, an ephemeral drainage which does not exhibit an ordinary high watermark. Gilman Gulch is 195 feet from the working pad surface, but is not located down gradient due to topography and the existing access road. The nearest down gradient water feature is Conch Creek. Conch Creek is an intermittent stream with a riparian habitat. Concrete is located 1,002 feet from the working pad surface. The map down gradient path is shown in blue lines in the figure before you. No wetlands were observed immediately downgraded as noted in the wetlands evaluation. There are no public water systems within 15 straight miles. All water wells within half a mile are monitoring wells. Based on public data from Colorado's Division of Water Resources, there are no domestic water wells within half a mile. Next slide. The 0607 is situated near existing facilities operated by Laramie as shown in the photo before you. The proposed buried gas pipeline and water line will be installed within an existing pipeline corridor, minimizing new disturbance. These nearby facilities will directly support operations at the 0607. This includes Laramie's central water treatment facility, concrete compressor facility, and a network of gas pipeline and water lines. Once in production, the 0607 will tie into infrastructure for the natural gas and water takeaway. These facilities and infrastructure will streamline development of the proposed 8 natural gas wells, significantly reducing truck traffic and surface impacts. Next slide. Laramie strives to utilize oil and gas locations and previously disturbed surface when possible. The 0607 was originally permitted prior to the adoption of the Form 2A process. The well pad currently has 2 producing wells. Upon OGDP approval and prior to expansion of the well pad, Laramie will plug and abandon the 2 existing wells. Next slide. The existing pad was not suitable in its current configuration and size to accommodate proposed operations and therefore requires expansion. The existing access road will also need to be widened in order to support anticipated traffic. Buried gas pipeline and water lines will be installed in the existing pipeline corridor. Laramie will also utilize a temporary surface water line for pre-production activities. These buried and temporary lines will significantly reduce truck traffic associated with the project. Next slide. The well pad and the access road were designed by a professional engineer, and the layout drawings are PE stamped. The 0607 expansion was designed to minimize overall disturbance while providing safe and efficient mobility for equipment and personnel. Laramie and KLJ Engineering spent significant time analyzing possible layout configurations and well pad designs. Laramie and KLJ refined site-specific design details to minimize disturbance, avoid direct impacts to the adjacent drainage, maintain a 500-foot buffer from concrete, and balance cut and fill volumes, all while considering the surrounding topography. Robust stormwater control measures were also incorporated into the design of the expanded wellpad and access road. The OGDP will result in a total of 21.8 acres of disturbance, which includes 9.8 acres of existing disturbance. The proposed area of disturbance is 14 acres with a working pad surface of 4.1 acres. The total access road will be 2.4 acres, which includes both new and existing disturbance. The proposed buried gas pipeline and water line will result in 5.4 acres of short-term disturbance. 17.4 acres will be reclaimed, which is about 75% of the construction disturbance. This includes 11 acres for the well pad, 5.4 acres for the pipeline disturbance, and 1 acre for the access road. The long-term disturbance is 4.4 acres, consisting of the production pad surface and the running surface of the access road. Only 25% of the project will be long-term disturbance. Next slide. The design of the well pad incorporates protective stormwater and drainage control measures and was designed to meet a 2-year, 24-hour event. Stormwater control measures were designed and reviewed by both a professional engineer and a certified stormwater inspector with extensive stormwater experience on the western slope. Laramie will install several stormwater control measures, including 2 stormwater retention basins, V-ditch and berm, and wattles. A V-ditch and berm will be installed along the perimeter of the working pad surface to convey water away from the pad and to concentrate flow alongside the pad perimeters and direct towards the retention basins. For the access road, KLJ Engineering incorporated several elements listed in the BLM Schoolbook standards. Next slide. During the production phase, Stormwater Retention Basin 1 will be recontoured and reduced. Stormwater Retention Basin 2 will remain the original construction size. The retention basin will provide stormwater protection for the production phase. Next slide. As part of planning and preparation for this OGDP, Laramie consulted with agencies listed before you. Laramie conducted 3 pre-application on-site meetings during which attendees had the opportunity to view the proposed 0607 development area, engage in meaningful discussion, and provide input regarding the project. After each on-site, Laramie emailed draft notes to attendees to provide further opportunity for additional feedback. Laramie gratefully acknowledges the input of local, state, and federal agencies whose contributions have shaped key elements of this project, as I will detail over the next few slides. Garfield County is a relevant government of the 0607, and there is no proximate local government. The 0607 is within the Resource Land Zone District. The small portion of federal surface is zoned as public lands. Communication with Garfield County occurred throughout the pre-application stage. Garfield County attended the May 15, 2025 onsite and the director's pre-application meeting. A Garfield County Article 9 oil and gas permit was not required for the 0607. In accordance with ECMC Rule 302E, advance notice was sent to Garfield County notifying of Laramie's intentions to submit an OGDP. The notification detailed proposed operations and traffic projections. Next slide. Laramie would like to express our appreciation to ECMC staff. This OGDP is Laramie's first hearing under the new Cumulative Impacts and Enhanced Systems and Practices rules, and we are thankful for staff's guidance during this OGDP. When Laramie was preparing the materials for the OGDP, Laramie decided to pursue a contracted area of evaluation. As stated in the Statement of Basis and Purpose, ECMC rules allow an operator to seek a contracted area of evaluation if certain conditions are met. When ECMC Rule 315B2A III states that an operator may utilize a smaller area of evaluation if the oil and gas location is outside the ozone non-attainment area and within area of topographic relief. This OGDP meets both criteria. Laramie consulted with Westwater Engineering first on guidance regarding an appropriate contracted area of evaluation. Westwater suggested utilizing a 7,800-foot elevation as the basis of the contracted perimeter due to a cliff band in the area. Laramie contacted ECMC staff requesting for a contracted area of evaluation, and on September 2nd, 2025, Laramie met with ECMC staff from the Cumulative Impacts team. ECMC staff agreed with the 7,800-foot elevation cliff band as a perimeter, but to expand it out to the 1 mile, as shown in the figure to the right. Staff also advised Laramie on which resources to apply the contracted area of evaluation and which receptors to use the default 1 mile. Laramie agreed and utilized staff's recommendations in the OGDP cumulative impact analysis. Laramie participated in the ECMC pre-application meeting on September 30th, 2025. During the pre-application meeting, Laramie presented a PowerPoint presentation which included information regarding general location details, photos, drone video, proposed operations, alternative locations, and high-priority habitat. Next slide. While the proposed wells will not target federal minerals, portions of the project occur on BLM surface. The BLM has a unique thin sliver of land surrounded by fee surface as shown in the images before you. The existing access road and pipeline corridor currently crosses the subject BLM parcel, and Laramie has an established right-of-way leases for these existing features. For disturbances associated with the well pad, Laramie had to pursue a new right-of-way. Disturbances for the well pad is less than 5 acres on BLM surface. Therefore, a categorical exclusion, known as a CX, is required. An environmental assessment, known as an EA, was not required for this project. Cultural and biological surveys were conducted in 2025, and those reports were provided to the BLM. Next slide. Laramie engaged with the BLM consistently throughout the project. BLM representatives attended an onsite on June 17, 2025. Laramie submitted the 299s to the BLM on November 18, 2025. On May 13, 2026, BLM provided an update that BLM is actively working through NEPA and anticipates final decision by mid-June 2026. Advance notice was sent to the BLM in October 2025, notifying of Laramie's intentions to submit an OGDP to the Commission. Next slide. 5 different high-priority habitats exist within 1 mile of 0607. I'll discuss high-priority habitat and CPW consultation over the next several slides. Laramie engaged with CPW throughout the planning and pre-application process. Next slide. CPW waived ALA criteria during the pre-application consultation. While an alternative location analysis was waived under Rule 309, Laramie wanted to take this opportunity to explain the history of site selection and CPW's role. Prior to selecting the preferred location, Laramie engaged with CPW to get CPW's perspective on locations that Laramie was considering. Laramie assessed several alternative locations during the preliminary planning of this development. Since several mapped high-priority habitats are within Concrete Valley, Laramie sought insight from CPW on these locations. Field surveys of the vicinity area were conducted in the fall of 2024, which allowed Laramie to present and discuss field verified data with CPW early in the planning process. Laramie presented these locations to CPW during the November 2024 onsite. Laramie originally planned on pursuing 2 locations for the OGDP. Laramie analyzed a total of 6 possible locations, including the preferred location, for the proposed project, and all the locations were mapped within HPH. Of the 6 locations assessed, 3 locations were existing, as shown in red, and 3 locations were new locations, as shown in orange. Due to the topography of Concrete Valley, the possible surface area feasible for development is limited. Steep slopes, mapped high priority habitat, and proximity to water resources were the main factors when considering and analyzing possible locations. The 2024 onsite with CPW provided beneficial discussion and on-the-ground assessment of which areas would be most protective. The 0607 along with ALA number 1 were CPW's preferred locations. After the first onsite, Laramie reassessed locations and ultimately was able to pursue 1 location versus the initial 2 location concept. CPW's feedback was a main component selecting the 0607 as the preferred location. Laramie's decision to pursue the 0607 based on CPW's input is a testament to our commitment to incorporating agency feedback. Next slide. After the location was confirmed and selected, Laramie conducted further consultation with CPW. CPW attended an onsite on May 15, 2025. During the onsite, CPW was able to observe the existing location, topography, access road, and vegetation. We discussed site design, the surrounding area, possible waivers, HPH, field surveys, timing of operations, best management practices, and other operational details. CPW attended the virtual directors pre-application meeting on September 30th, 2025. CPW did not state any concerns during this meeting. CPW approved the Wildlife Mitigation Plan on December 2nd, 2025. The Wildlife Mitigation Plan included timing of proposed operations, traffic projections, acreage disturbance per high priority habitat, mitigation fee, photos of the surrounding area, and best management practices. Next slide. Parts of the 0607 OGDP are located within HPH, as shown in the table before you. Laramie is communicating and consulted with CPW on timing of operations, number of occupations, and anticipated truck traffic. Next slide. The existing production pad is currently located within Aquatic Sport Fish Management Waters Buffer. Field surveys were conducted and determined that the subject mapped aquatic buffer is based on ephemeral drainage, Gilman Gulch, which does not exhibit an ordinary high watermark. Westwater concluded Gilman Gulch is not suitable aquatic habitat. Gilman Gulch is not down gradient, and the expansion of the 0607 will not result in direct disturbance to this ephemeral drainage. The nearest down gradient water body is Concrete. While the 0607 well pad is outside the Concrete's mapped aquatic sportfish HPH buffer, a small portion of the access road and buried pipeline corridor is within this HPH. The installation of buried pipelines will not result in surface disturbance to stream beds, nor will cross any water bodies. Next slide. A segment of the access road is within mule deer severe winter range and winter concentration area. The existing access road will be widened to provide safe and efficient vehicle access during operations. Laramie will pay the direct impact mitigation fee for the 1.1 acres of new disturbance within this HPH. Next slide. The well pad and access road are located outside Elk HPH. However, a portion of the proposed buried pipeline will be installed within Elk winter concentration. The pipeline installation will take 30 days to complete, and the pipeline will be immediately reclaimed upon finishing installation. Thus, any disturbance within Elk winter concentration will be short-term. Additionally, all the proposed buried pipelines will be installed within an existing pipeline corridor and adjacent to existing Laramie facilities where human activity already exists. No long-term surface disturbance to elk habitat will occur from this OGDP. Next slide. Laramie submitted waivers requests to CPW on October 11th, 2025. The waiver request included the following information: wetlands evaluation, HPH assessment, timing of operations, traffic projections, HPH maps, hydrology maps, acreage disturbance per HPH, and other operational details. CPW approved the waiver since Gilman Gulch is an ephemeral drainage that does not exhibit an ordinary high water mark and is not a suitable fish habitat. Laramie prioritized utilizing existing infrastructure and disturbances, and the OGDP is designed with protective measures. CPW approved the waiver request on October 17th, 2025. Next slide. This slide summarizes duration for operations at the 0607. Due to limited water capacity in the Cascade Creek area and the exploratory mineral development proposed in this OGDP, Laramie is planning 2 occupations. Laramie strives to utilize recycled produced water to the maximum extent. 2 occupations will allow Laramie to increase the amount of produced water. Laramie is proposing 10% recycled produced water for this project. I wanted to provide an update on the last OGDP Laramie presented to the Commission. The CCR OGDP, which was presented to the Commission in May of 2025, originally proposed 100% fresh water use. Laramie is happy to inform the Commission that we were able to utilize 40% recycled produced water during pre-production operations at the CCR. Laramie's ongoing commitment to use recycled produced water is a commitment, and even after hearing, we will continue to seek opportunities and solutions to increase produced water use. Next slide. Listed before you is a summary of our proposed air monitoring program. Laramie is currently preparing an air monitoring plan to submit to CDPG. Next slide. Laramie will implement numerous best management practices to minimize and mitigate potential impacts, which best protects public health, the environment, safety, and wildlife resources. Next slide. Before you are the highlights and summary of the cumulative impact analysis. Laramie's efforts to utilize existing infrastructure, existing disturbance, reduce truck traffic, avoid receptors, consult with regulatory agencies, and incorporate the most protective designs are reflected in this OGDP. Approval of Laramie's 0607 OGDP is an important component of the local economy. Additionally, Laramie is proud to support DeBeck School District, Fire Station, Garfield County 4-H programs, and other local organizations through donations and volunteer work. And now I will return the presentation back to Ms. Wazelinki.
Thank you, Ms. Middleton. To summarize the 0607 OGDP and request for approval, I'll note the following highlights. The OGDP proposes the use of an existing well pad, access road, and pipeline corridor to minimize surface disturbance and traffic impacts. CPW again waived ALA after a robust consultation and concludes that CPW believes this application effectively avoids, minimizes, and mitigates adverse impacts to wildlife resources, and there are no outstanding issues or additional recommendations from CPW at this time. And finally, the siting and BMPs provide protection of public health, safety, welfare, the environment, and wildlife resources by avoiding, minimizing, and mitigating adverse impacts. With that, we respectfully request approval of the OGDP and associated Form 2A, as well as the 2 drilling and spacing units. And this does conclude our presentation. So we can go ahead and take the PowerPoint down. And we have a team of subject matter experts from Laramie who are open for any questions.
Thank you very much. Commissioners, we have a group ready for questions if anyone has any. Commissioner Ackerman?
Thank you, Mr. Chair. Just one question. I appreciate the presentation. Appreciate the work done and the thoroughness of the presentation, the documentation. And I wanted to recognize your significant cooperation with CPW and appreciate that. I just wanted to touch on the 2 occupations. You addressed the produced water use there, but I did note that the preponderance of the development is taking place through the winter months on both occupations, and it's generally not the best time for occupation in or near high priority habitat. And I do recognize that the primary high priority habitat here is the aquatic sport fish management water, which really doesn't really apply to. But with regard to the big game proximity high priority habitats, it could be less impactful to do it in the summer months there. And you're not in the ozone non-attainment area, and so you don't really have to worry about timing there. And so I just wanted to ask, was there other timing considered that would further avoid those areas in winter? And just kind of why this schedule? Just produced water use, or are there other factors?
Thank you so much, Commissioner Ackerman, for the question. Right now, Laramie does not have a drilling inventory, and so this will be the first OGDP approved under the new cumulative impacts rules. So we came up with this schedule anticipating receiving the permits and being able to start drilling again. And so we had to take into account, of course, this is higher elevation. We had to take into account construction, timing, etc. And this is where the schedule kind of laid out for us. And we consulted with CPW on the timing. Since it is a existing location and it is kind of, we would refer to as a cluster development, there's several other oil and gas locations within the proximity. When we consulted with CPW and Westwater Engineering, the animals or wildlife in that area would be somewhat habituated to human activity. And therefore we did not feel that it was like being in like a remote, undeveloped HPH.
Thanks for that response. I think that's all I've got, Mr. Chair.
Great, thanks. Good questions. Other questions, Commissioner Messner?
Thanks, Mr. Chair. So I wonder if you could talk a little bit more about the produced water recycling and barriers associated with that, and then I acknowledge that I believe you've committed today to 10% reuse and recycling. I didn't see that as a BMP on the Form 2A unless I'm missing it. And so maybe just go in a little more depth about the produced water recycling.
Yes, thank you, Commissioner Messner. Laramie has committed to 10%, and that is within our outlined within our water plan, and I believe also the plan of development document. So while I know 10% seems probably like less than what you may see on in the Piceance Basin, because of the larger volumes that are required for completions for horizontal wells, it kind of drops our percentage. We are also constrained by current capacity of our water treatment facility. So by staging it out over 2 occupations, we believe that is the best way to utilize the most produced water possible, because it will allow for recharge of our current volumes.
Okay, and are those, as your current treatment facility, that is being fed by additional wells besides this pad?
Correct.
And then with the first occupation, you would then direct your produced water and flow back into your treatment facility from the horizontal drills as well?
Correct. This is also a Niobrara development, and so Niobraras are typically considered drier wells. So we do not anticipate the amount of flowback that we would probably see with, say, for example, a Williams Fork Isles development. And this is our first Niobrara development exploratory in the Cascade Creek area. So we actually don't have a great feel on what volumes we will receive back from flowback and during the first year of production.
And then a question for staff, because again, unless I'm missing it, that 10%, while I believe it was captured in the water plan, I'm not sure it was captured as a BMP on the Form 2A. And so unless I'm missing it, I wonder if that needs to be added or not. That's all, Mr. Chair.
Further questions for the panel? Okay, seeing no further questions, we move to deliberations. If the panelists could unvisualize, we'll return it to the commission for thoughts. Anybody desire to start? Commissioner Ackerman, thanks.
Thanks, Mr. Chair. And again, thanks for the presentation. I mentioned HPH and that there are multiple HPHs here. I appreciated your map and your demonstration and your consultation with CPW as to how you worked with them associated with those HPH. And to be honest, this is one of the least impactful OGDPs on the West Slope that includes multiple HPH intersections that I've seen, and I appreciate your attempts to address those. It's an existing location. The existing wells will be P&A'd prior to construction. They'll have personnel on site full time, inspected daily during production phases, at least 2 to 3 times per week, remote telemetry, SCADA, and a number of other best management practices that they worked with CPW and others on. And so I appreciate your extensive work with them. I think this also includes some direct impact compensatory mitigation payment, and you can correct me if I'm wrong there, but I believe it's the flat fee payment. which I think has been negotiated with CPW. And would just note that CPW has stated that they believe the application effectively avoids, minimizes, and mitigates adverse impacts to wildlife resources, and that they don't have any outstanding issues or additional recommendations. And I don't either, Mr. Chair. That's generally all I have on deliberative comments. Thanks.
Thank you. Further comments from the Commission? Commissioner Messer?
Yeah, I think my primary comment would be that I think we need a condition of approval that puts the 10% reuse and recycling commitment on the 2A. While I understand that it's in the water plan and so ultimately is enforceable, I think any BMPs that are being committed to need to be captured in the 2A because that's really the document that gets looked at, not the associated documents, and determining what the BMPs committed to actually are. So I would say that. And then, I did struggle a little bit with this one in trying to understand, at least from the director's recommendation, what was being committed to, because the director's recommendation didn't have a lot of detail in it as far as, the pipeline commitments, the tanks, the produced water commitments, elements that I've typically come accustomed to see in director's recommendations. So I actually had to dig through the 2A and the associated documents and develop my own list, which is fine, but I think it's important to highlight these elements in the descriptions within the director's recommendation. So that's all.
Thank you. I missed the first part. My Wi-Fi turned off, so back on cellular. Others with comments? Commissioner Oath?
Thanks, Mr. Chair. I think the only additional comment I would make is just a recognition and of the discussion around modified and contracted area of evaluation. We haven't seen many of those, and so I appreciated what was brought forward and discussed with respect to that in this case. So.
Yeah, agreed. Anybody care to make a motion? Commissioner Ackerman?
Thanks, Mr. Chair. I'd be happy to make a motion for approval and would look for some consult from AAG Boudreaux on what we would add as a COA as suggested by Commissioner Messner.
Thank you. Staff is able to put together some language for a COA. They're requesting about 5 minutes to do that, if that's okay. The COA for the produced water requirement, 10%.
Okay. We always want to accommodate staff's request for us that time. Let's return at 2 o'clock. That's 7.5 minutes. All right, AG Boudreaux, did you have a chance to chat with staff?
I did. Thank you, Mr. Chair, for the time to put together some language. So I'd recommend a motion to approve the application as applied for, but with one condition of approval, which reads as follows. Operator will utilize not less than 10% recycled produced water for well development operations prior to the production phase.
All right, thank you very much. Ms. Wozlinki?
Yes, that's acceptable to Laramie.
All right. Commissioner Ackerman, is your motion so amended?
So amended.
Second.
All right. Motion and the second has been amended to include that condition. Is there further discussion on the motion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? That motion carries. All right. Thank you very much, Ms. Wesselinki, although I think either you or Ms. Jost are on board for the next one.
Yes.
Is it you?
It's me.
All right. Do you want to just raise your people and we'll just kind of keep plodding forward? Is that okay?
Sure. They're ready to be admitted. I don't see them on the panel yet.
And this is the WaveTech
Correct.
Helium Project 250800172.
Correct. Looks like they're coming on now.
I promise everybody, this is so much more easy than being in person and bringing everybody to the dais with 13 different pieces of paper. So bear with.
It looks like we may have everyone except for Patty Vogel. But if we don't see her in the hearing, I think we could probably, oh, there she is. Great. I think we're ready to be sworn in.
All right. If all the witnesses could visualize themselves, Mr. Boudreau will swear everybody in.
Thank you, Mr. Chair. I'll ask all the witnesses to be visualized. When I call your name, raise your hand, state your first and last name, and swear to tell the truth. Coulter Anderson.
I, Coulter Anderson, swear to tell the truth.
Igor Gendelman.
My name is Igor Gendelman, and I swear to tell the truth.
Andrea Gross.
My name is Andrea Gross, and I swear to tell the truth.
Patty Vogel.
I'm Patty Vogel, and I swear to tell the truth.
David Eby.
I'm David Eby. I swear to tell the truth.
David Bowen.
My name is David Bowen. I swear to tell the truth.
Thank you. Did I get everyone, Ms. Wozlinki?
You did. Thank you.
Thank you.
All right. Let's move into your PowerPoint and presentation.
Great. Thank you, Chair. We'll get that PowerPoint up and running. Then I'll get started. I think it just needs to be in presentation mode. Perfect. Okay. Well, good afternoon again, Commissioners. My name is Kelsey Wozlinki with Jost Energy Law, and with Jamie Jost, we represent WaveTech Helium in the state helium OGDP before you today in docket 2508-00172. We would like to thank Kit Carson County for their support of the OGDP and also ECMC staff and the director for their efforts on this OGDP. Next slide. This OGDP requests approval of an approximate 640-acre oil and gas development plan for the development of 2 new vertical wells from 2 new locations to target helium gas in the Morrow V3 sandstone. The 2 requested Form 2As are for the number 2 WaveTech State 2236 and the number 1 WaveTech State 2436 as shown on this map. WaveTech will utilize existing 320-acre spacing units in Section 36 to drill and develop both locations in the Morrow V3 sandstone. All gas produced from the Morrow Reservoir will produce directly to the existing Ladder Creek pipeline system. WaveTech does not expect to produce oil as part of this development. The 2 proposed locations are within Kit Carson County. Kit Carson County does not regulate the siting of oil and gas locations. However, WaveTech has been in communication and consultation with Kit Carson County and has the county's full support. The proposed locations are all within the Lesser Prairie Chicken estimated occupied range, but are not within any connectivity area. WaveTech will discuss its consultation with CPW, CPW's waiver of ALA for both locations, and how the siting and BMPs will protect this habitat in the presentation today. The Director's recommendation for approval of the OGDP contains 1 condition of approval, stating that WaveTech shall provide the approved copy of the Emergency Response Plan to staff via Form 4 Sundry prior to construction of the location. WaveTech agrees to this COA. And finally, WaveTech has complied with all notice requirements for the OGDP. No formal petitions were filed and no public comments were received on the Form 2As. I'll now turn it over to Coulter Anderson with WaveTech to continue the presentation.
Thank you, Kelsey. Good morning, Commissioners. My name is Coulter Anderson, and I'm a geologist at WaveTech Helium. I appreciate the opportunity to present the State Helium OGDP. Next slide. Helium is an essential element for many industries, and there are substantial reserves in southeastern Colorado. WaveTech staff has a lot of geologic knowledge and operational experience in this area, and we are leveraging it in our efforts to produce helium. Next slide. 9 ODDPs have been approved by ECMC, totaling 25 locations. WaveTech is actively permitting, drilling, and producing. Helium-containing gas is going into the Ladder Creek Helium Plant gathering system, which then takes it to the helium plant. OGDP 11 and 12 will be filed imminently. Next slide, please. Excuse me. This is an overview of the number 2 WaveTech State 2236 location. We've consulted with Kit Carson County. We plan to drill 1 conventional vertical well at this location, targeting helium, which is a component of the natural gas system. All the gas production will go into the already existing Ladder Creek plant through the existing pipeline system. It is on state surface and minerals and will have a total pad disturbance of 3.6 acres. The proposed location is within the Lesser Prairie Chicken estimated occupied range. This location is rangeland adjacent to cultivated agriculture, close to a number of wind turbines, which limit any significant use of the site by lesser prairie chickens. The nearest lek is more than 5 miles away. CPW waived ALA under Rule 304B 2B8. This location is more than 2,000 feet from residents and schools. Next slide, please. This is an overview of the number 1 state 2436 location. This location has the same bullet points as the previous one, and the nearest lek is 5.5 miles away. Next slide, please. Target for these wells is the Morrow V3 reservoir, which is a fluvial channel sandstone-filled incised valley. The reservoir is highly permeable and is part of a separate gas accumulations as shown on the geologic testimony cross-section. Spacing order 477-3 will be utilized to drill 2 wells to develop Morrow V3 and shallower Morrow sandstones. Next slide. This is the permitting timeline. No public comments were submitted on the Form 2As and no petitions were filed. Next slide. This shows the phases of operation. Pad construction will take about 4 days per location. We will drill 2 new wells. Each well will not take more than 14 days. Basic production equipment will be installed if the well is productive, and all gas will go into the already existing pipeline. Next slide. The next 2 slides are wildlife protection slides. All locations are within lesser prairie chicken estimated occupied range. However, each location is near wind turbines, which limit any significant use of the site by lesser prairie chickens. This well has 4 wind turbines within 1,800 meters, which can be seen on the map. All locations are far away from Lex. This one is 5 miles away from the nearest one. WaveTech consulted with CPW, and CPW has waived the ALAs. Next slide, please. The State 2436 well has 5 wind turbines within 1,800 meters, and the nearest lek is 5.5 miles away. Next slide. Best management practices matching all previous OGDPs will be used for these locations. Construction will only take place during daylight hours. The infrastructure, tanks, and other storage will be outside the 500-foot buffer from the ordinary high water mark. Berms will be utilized to control sediment migration. No uncontrolled stormwater will be directed off the pad. Diversion ditches will direct stormwater to sediment traps. No mud pits will be used, and no combustors will be used during production. All gas will go into the existing pipelines. Next slide, please. All surface locations are on Colorado State Land Board surface and minerals. The land is currently used for crop grazing and wind turbines. WaveTech will not use oil-based mud. No pits will be required. No permanent combustors will be used, and all the gas will go into existing pipelines. CPW states that the expected noise level are permissible, plus the duration of these phases will be brief. There are no residential buildings within 1 mile of all working pad surfaces. Now with that, I'll pass this presentation back to Kelsey.
Thank you, Coulter. To summarize the state helium OGDP and WaveTech's request for approval, WaveTech cited both locations to avoid, minimize, and mitigate potential adverse impacts. CPW waived ALA for both locations, which are in close proximity to wind turbines and far from the nearest map LEC locations. WaveTech agrees to the COA contained within the director's recommendation regarding the emergency response plan, and no petitions or public comments were received on the 2As, and the director recommends approval. Next slide. This final slide just shows the relief requested for the OGDP. We respectfully request approval. This now concludes our presentation, so we can take the PowerPoint down, and we have a team available for any questions.
Great, thank you very much. Once again, commissioners, we have a panel available for questions on this OGDP. A rare happenstance, I'm seeing no questions. Do commissioners want to move to deliberations? Commissioner Master?
I'll move approval of the application as presented, including the condition of approval included in the director's recommendation.
Second.
Motion and a second. Is there further discussion on the motion? Commissioner Ackerman?
Not on the motion, Mr. Chair, but I did just want to say thank you for your continued work on working with CPW to mitigate any impacts to lesser prairie chicken. Lesser prairie chicken continues to go through a sordid and difficult legal listing situation under the ESA, but CPW remains and strong in their HPH designations with lesser prairie chicken, and we work generally with under those. Wanted to say how much I appreciate the care that goes into working with CPW on this issue. Thanks, Mr. Chair.
Appreciate those comments, Commissioner Ackerman. Further comments? All those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? That motion carries. All right, we have one more docket. It's a different attorney and a different applicant, so let's take a few minutes. Let's return at 2:20, and we'll take up that last docket. Thanks. All right, welcome back, commissioners. ECMC hearing docket continues 2:20 on Wednesday, June 3rd. We take up docket 241200314, an oil and gas development plan. The applicant is Petroleum Resource Management Corporation. The subject is the Welba Peak 1 OGDP. And I believe before we hear from the applicant, we're going to hear from Emily Waldron, ECMC Senior Location Assessment Specialist. Hearings Manager Thomas, am I a liar, or is that still on the docket?
Oh, my apologies, Mr. Chair. We've elevated Ms. Waldron.
Okay, great. Good morning, good afternoon, Ms. Waldron.
Good afternoon, commissioners. My name is Emily Waldron. I'm a senior location assessment specialist and the lead for this OGDP. Staff appreciates the time to correct discrepancies between the hearing application and the director's recommendation in Form 2A. The hearing application contains a variance request from Rule 1003 regarding interim reclamation timing. The hearing application correctly states that the interim reclamation will be delayed for up to 27 months following the setting of conductors for the initial wells drilled on the pad. On page 6, the director's recommendation incorrectly states that the interim reclamation shall commence no later than 27 months from the commencement of construction. Like the hearing application, this should have stated 27 months following the setting of conductors for the initial wells drilled on the pad. Page 6 of the director's recommendation is also missing the 3 additional conditions of approval found on the Form 2A. The 5 conditions of approval found on page 13 of the Form 2A should be included in the consideration of this application. Should this application be approved, staff will update the conditions of approval number 2 and 5 to reflect the language in the hearing application, updating them from stating Interim reclamation shall commence no later than 28 months from the commencement of construction. To state, interim reclamation will be delayed for up to 27 months following the setting of conductors for the initial wells drilled on the pad. Thank you for your time, and I'm happy to answer any questions.
Anybody have questions with regard to the clarifications? Thanks for bringing them to our attention. We appreciate it. We know there's a ton of work done by staff on these things, so thank you very much.
No
All right,
problem.
Mr. Priscilla, do you have your witnesses available for being sworn in?
I do. I see Ms. McKinley, Mr. Cooper, and Mr. Shepard. They're available to be sworn in. And just for
Mr.
clarity, Ms.
Thank you. What a-
Moda is not testifying as a witness. She's
Okay.
having a presentation. Thank you.
I'll ask each of the witnesses to be visualized. When I call your name, please state your first and last name. And raise your hand, state your first and last name, and swear to tell the truth. Joey or Joy McKinley.
Joey McKinley, I swear to tell the truth.
Duncan Shepard.
Duncan Shepard, I swear to tell the truth.
Chris Cooper.
Chris Cooper, and I swear to tell the truth.
Thank you. Did I get everyone, Mr. Paschal?
You did. Thank you.
Thank you.
All right, go ahead and roll it.
Great. Thank you. Good afternoon, Chair Robbins and Commissioners. My name is Joe Pershala. I'm a shareholder with Wellborn, Sullivan, Meck, and Tooley, and I represent Petroleum Resource Management, or PRM for short. We recognize that it's been a long day for you, so we'll try our best to be efficient working through our presentation here today. As always, I'd like to first thank staff for their work assisting PRM to prepare and present this OGDP to you today. I and the PRM team are pleased to bring before you the Welba Peak 1 OGDP. This OGDP is an integral part of PRM's exploratory development of an area covering more than 25,000 acres and represents the next step in PRM's deliberate approach to proving the resource with a primary focus on avoiding disturbance and impacts by selecting optimal locations in close consultation with the landowners, CPW, and ECMC staff. Before I jump into the specifics of the OGDP, I wanted to briefly speak on some of PRM's efforts since the hearing on the Welba Peak 2 OGDP last fall and updates on its work with stakeholders. First, as you know, PRM has engaged Fielding Hill to manage and oversee all aspects of its regulatory, permitting, and field work. This partnership has put in place standard operating procedures to ensure regulatory compliance, to provide a central point of contact with all local governments and agencies, and to coordinate vendors and field personnel. Internally, Fielding Hill has developed a custom compliance software program that accounts for all of PRM's major field operations, and this is to ensure that every step of planning and operations comply with all state, local, and federal regulations. Just some of that work that Fielding Hill is doing includes weekly regulatory compliance meetings, coordination with the surface owners for surveys and on-site resource meetings, conducting desktop and field environmental surveys, evaluating and preparing new locations, representing PRM on various industry task forces and working groups, and regular consultation with all agencies and local governments. In sum, PRM heard you loud and clear, and it is proud to say that it is working in the most diligent and transparent manner to demonstrate to you that it is an operator that you can trust and that it is meeting and exceeding ECMC's regulatory standards. The second item I'd like to talk about is the cornerstone of PRM's approach to this development, which has been communication and collaboration. As evidenced in the agency consultation summary that's been submitted with the application, PRM has participated in dozens of consultations with applicable agencies. Since the Welba Peak 2 hearing alone, PRM has been engaged with ECMC, CPW, and local governments not less than 9 occasions to discuss its Welba Peak development, including current and future operations. PRM is in regular consultation with the surface owners, keeping them informed of all current and future operations, and continuously consulting with them for planning of locations, rights of way, and access. These surface owners are partners and the foundation of Welba Peak development, which is a best-in-class project prioritizing the avoidance and minimization of impacts. This Welba Peak 1 OGDP that was submitted to ECMC over a year ago is only the second step in this Welba Peak project. we are cognizant that you want to see how this and other planned locations are going to fit together in the broader development scheme, and how PRM intends to coordinate its operations to avoid, minimize, and mitigate impacts. To that end, planning of additional locations is underway, and in coordination with ECMC staff, PRM looks forward to bringing those plans and application before you in the coming months. And with that, I'd like to speak to our Wellwood Peak 1 OGDP and ask that Ms. Oda bring up the hearing presentation. Thank you. So for the Wellwood Peak 1, we have Joey McKinley, who is PRM's regulatory consultant and partner at Fielding Hill, be doing the presentation. And available for commissioner questions are Duncan Shepard, president of PRM, and Chris Cooper, who serves as the environmental and natural resources consultant with Fielding Hill. This application requests the commission approve an oil and gas development plan covering approximately 4,190 acres, lands that are within Township 11 North, ranges 88 and 89 West, within Moffett and Routt counties. The application requests the commission approve a Form 2A for the proposed WPU 25-5 pad. It's sited in Moffett County, and we're proposing 8 horizontal wells on the pad for the development of the Niobrara Formation. The pad is within the mineral development area, and which is all within an existing federal unit, the Wellwood Peak Exploratory Unit. Because the lands are in that exploratory unit, a spacing application was not submitted with the OGDP. The location itself is on fee rangeland surface and proposes a small working pad surface disturbance of approximately 5 acres. While the location is near 2 non-primary residence RBUs, the owners did sign informed consent. With respect to other ALA criteria, the location is subject to Rule 304B2B Romanet 8, as it is within mapped high priority habitat for elk, Columbian sharp-tailed grouse, and greater sage grouse. PRM performed an ALA that evaluated and considered 4 alternate locations, all of which are also in the same HPH. In consultation with staff, CPW, and other stakeholders, the WPU 25-5 pad was selected as the best of the alternatives. PRM has worked closely with CPW regarding this location, and those efforts, as you will hear, resulted in collaboration with CPW in acquiring conservation easements, CPW's support for the WPU 25-5 pad as the best suited alternative, and an agreement to avoid construction and drilling operations during the applicable wildlife timing steps. The Commission's review here today is under Rule 301A. That is whether the proposed operations will protect and minimize adverse impacts to public health, safety, and welfare, the environment, and wildlife resources. As you will hear, PRM has evaluated this project with the primary goal of avoiding impacts and thereafter to minimize and mitigate any unavoidable impacts, including the selection of a location that avoids human receptors. You'll hear that they're going to use a Tier 4 or equivalent drilling rig, Group 3 drilling mud. All production will be transported off location via existing flow line, and the production will flow to the Duncan facility, at which point gas will be piped downstream, oil will be hauled, and upon ECMC approval, water will be disposed of in the WPU 14-1 PWD number 1 UIC disposal well. Briefly, I'd like to mention about the Duncan facility. The delivery from the WPU 25-5 pad will not require a significant change to the footprint, design, or operation of the facility. I understand that at the hearing on the Wellwood Peak 2 OGDP, that you expressed frustration that you did not have an opportunity to review the Duncan facility under the OGDP process. While the Wellwood Peak 1 OGDP does not revisit the Duncan facility, PRM is committed to bringing that facility before you as part of its next application, which we anticipate filing in the coming months. And PRM looks forward to revisiting that facility with you at the time. As it concerns Wellwood Peak 1, the use of the facility furthers the ECMC regulations that drive the avoidance and minimization of impacts, including the directive to utilize existing disturbance in locations wherever possible. Briefly, with respect to cumulative impacts, this application was filed prior to the effectiveness of the cumulative impacts rules, so a cumulative impacts analysis was not required. As I mentioned, Moffett County is the relevant local government. The county does not require a permit for the WPU 25.5 pad, and there are no proximate local governments. As part of this application, there's also a variance application. PRM is seeking a variance to the interim reclamation timing requirements under Rule 1003B due to the HPH wildlife timing steps that limit PRM to an annual 4-month operation window to conduct construction, drilling, and completion operations. This variance will allow PRM to utilize that narrow operational window to focus its efforts on development and avoid a cycle of redisturbance associated with interim reclamation. Thus, the variance will actually minimize impacts, including the minimization of topsoil loss. During the variance period, PRM will maintain compliance with ECMC rules and Form 2A plans to prevent runoff, erosion, and noxious weeds. As part of this variance, PRM has also agreed to remit additional financial assurance in the amount of $417,231. ECMC staff and CPW both support this variance. With regard to notice, PRM has given proper notice under ECMC rules, and no petition or protests were received. And on May 14, 2026, the director recommended conditional approval of the Wellwood Peak 1 OGDP, including approval of the variance to Rule 1003B, subject to certain conditions of approval, which PRM has agreed to. Thus, PRM respectfully requests that the Commission adopt the Director's recommendation and approve the Wellwood Peak 1 OGDP and associated variance request. Thank you very much for your time this afternoon. And with that, I'd like to pass the presentation to Ms. McKinley.
Thank you, Mr. Pershala. Good afternoon. My name is Joey McKinley, and I am partner with Fielding Hill LLC here on behalf of Petroleum Resource Management, or PRM. As Mr. Pershala stated, PRM is grateful for the opportunity to present the Wellwood Peak 1 OGDP for your consideration today. PRM would like to thank Moffett County, ECMC, CPW, CDPHE, and BLM staff for all their time and attention throughout the application process. Because PRM is presenting its second OGDP before you today, we will provide a brief refresher of the Wellwood Peak Federal Unit development. PRM is an independent oil and gas operator that has been contracted to operate the unit by the Wellwood Peak Group. In partnership with Carmody Exploration, an investor group of several small family-owned oil and gas companies, the Wellwood Peak Group has worked for 20 years to create and begin development of the federal Wellwood Peak unit. The Wellwood Peak Group has demonstrated significant investment of $70 million in the project to date, having only received about 10 months of production from the most recent well that was shut in since 2020 to abide by ECMC's no flaring rule, and only recently resumed production. With eventual infill development of the unit, the area counties may see several $100 million in ad valorem taxes, an impactful investment, as one of them is a disproportionately impacted community. Because PRM is the operator of record, we will refer to them throughout the remainder of this presentation. The Wellwood Peak Federal Unit surface is comprised of several large ranches, many of which have been owned and operated by the same families since patent. Some parcels have several hunting or vacation cabins, and other areas are covered by large swaths of wildlife, conservation easements, and public lands. As you have seen from the letters of support received for this application, the ranchers in this area from both Moffett and Routt counties are supportive and interested in the success of the Wellwood Peak Unit development. The Wellwood Peak Federal Unit, originally formed in 2016, is situated in far northeastern Moffett and far northwestern Routt counties, less than 10 miles from the border with Wyoming. The unit is comprised of approximately 25,000 acres of both fee and federal minerals, with a unit obligation to drill 2 wells per year. The unit is currently in an exploratory phase, meaning that new acreage must be drilled to hold it within the unit. By building gas takeaway and a gas processing facility before fully delineating the production capacity of the area, PRM is invested in the long-term development of the unit. The Wella Peak 1 OGDP consists of one location, the WPU 25.5 well pad. The 25.5 would be located on fee surface, and PRM is proposing 8 horizontal Niobrara wells, that will access both fee and federal minerals. The location and its access road would have a total of 10.09 acres of initial disturbance with a working pad surface of 5 acres. After interim reclamation, the total long-term disturbance would be 2.56 acres, including the access road. There would be no permanent production storage on the location, as oil, gas, and produced water would be taken away by existing flow line. The nearest RBU is situated at 804 feet southwest of the working pad surface. The next nearest RBU is situated at 2,024 feet northeast of the working pad surface and is owned by the surface owner of the well pad. Both RBUs are not primary residences and are temporarily or seasonally occupied. PRM obtained informed consents, and the owners submitted letters of support during public comment. Before diving into community outreach, it is important to understand the community. Moffat County is populated by just over 13,000 people. Of these, approximately 70%, or around 9,000 people, live in or near the city of Craig. Approximately 4,000 people populate the rest of the county, which is the second largest in Colorado by land area. So it is easy to visualize the Wella Peak development area is sparsely populated. When this OGDP was submitted in December 2024, the CDPHE EnviroScreen 1.0 was used to assess demographics and climate impacts of the population for this area. As shown on the right-hand side of this slide, the 2024 DI community type is a Justice 40 tract, with the primary driver being a climate vulnerability score of approximately 97. EnviroScreen 1.0 also designates this area as a low-income population. This area has an EnviroScreen 2.0 score of 32.85. It removed the low-income population designation and reduced the climate vulnerability score from approximately 97 to 49. These are just numbers, but the Welba area community, they work countless jobs to support each other. They farm and ranch. They serve on local boards. They are their own emergency response until agencies can arrive from 20 to 40 minutes away. They help each other build fences and move cattle. These are folks who are not just RBU owners. They are friends and partners of PRM in the development of this unit. As mentioned previously, PRM has worked closely with the owners in this area for 10 to 20 years. Specifically related to the RBU owners near the 25.5 well pad, PRM has made many connections with the owners over the years, from negotiating surface use agreements and mineral leases to circulating informed consents and holding robust discussion at community meetings. PRM worked with one of the RBU owners to release approximately 1,100 acres from their surface use agreement so that the rancher could place those lands into a conservation easement. Agency consultations for the WPU 25.5 began as far back as 2017. PRM has coordinated closely with Moffat County for county road maintenance, development of the emergency response plan, and the county has received multiple OGDP notices. Coordination with CPW has been a key component in PRM's planned development of the Wella Peak unit. PRM consulted extensively with CPW, and CPW approved PRM's wildlife mitigation plan. We will discuss the compensatory mitigation plan in an upcoming slide. PRM consulted with ECMC staff many times in the development of this application that was submitted in December 2024. Consultations with CDPHE occurred in December 2024 and April of this year. PRM operates under an approved stormwater permit, and PRM will engage in future consultations with CDPHE for air monitoring activities. Lastly, the Welba Peak 1 OGDP will develop unitized 97% federal minerals, 20% fee minerals, and 1% state minerals. PRM consulted with the BLM several times throughout the application development, and BLM APDs are approved. The 25-5 well pad is situated within Rule 1202D2 density habitats for elk migration and elk production, and the Rule 309E1 consultation habitats for Columbian sharp-tailed grouse, winter range, and greater sage grouse general habitat management area. The combined terrestrial wildlife timing limitations span from November 15th through July 15th. PRM consulted with ECMC location assessment and reclamation staff and CPW jointly to arrive at a pre-production schedule that prioritizes avoidance of sensitive breeding seasons. While developing this OGDP application, PRM worked with CPW to develop a compensatory mitigation plan for the direct impacts of the WPU 25-5 as a Rule 1203B operator completed mitigation project in lieu of simply paying mitigation fees. The compensatory mitigation plan details that in 2024, PRM, CPW, and Colorado Open Lands purchased a perpetual conservation easement in the vicinity of the Welba Peak Federal Unit. This easement links together several existing conservation easements and prohibits development and land conversion. This easement helps protect more than 800 acres of greater sage grouse, elk, and mule deer high priority habitat. PRM supports conservation efforts and is appreciative to CPW, Colorado Open Lands, and the surface owner for the opportunity to be a part of this significantly beneficial conservation easement and mitigation project in proximity to its operations. When evaluating siting for this new well pad, PRM considered 5 locations. The area immediately west of the well pad has a no surface occupancy provision in the mineral lease, which excludes it from consideration. All locations were considered for their ability to delineate a new mineral lease area within the federal unit and for their proximity to County Road 124 and existing flow line infrastructure. Alternative location 1 was excluded due to steep slopes and the significant cut fill that would be required for construction. Ongoing stormwater maintenance with these slopes would be an issue as well. Alternative location 2 was excluded because it is closer to a known geohazard area on the opposite side of County Road 124. Alternative location 3 was excluded because it is the closest location nearest to the RBU at 493 feet southwest and would require a variance to Rule 604A4. Alternative location 4 is the flattest area and most suitable location for construction with minimal cut and fill. However, it is the farthest alternative location from flowline takeaway. Alternative location 4 is situated within a rancher's hayfield, and PRM would not be able to obtain an SUA for the location. Ultimately, the proposed location is the next flattest location in terms of topography. It is situated near infrastructure, and it is situated as far as possible from the 2 RBUs and known geohazards. When evaluating where to site the production facility equipment to support the proposed 25-5 wells, PRM considered areas immediately adjacent to the existing infrastructure. Looking around the proposed well pad, the same areas were eliminated for reasons already described. No surface occupancy immediately west of the proposed location. Alternative location 1 provides an undesired closer proximity to RBU 1. And alternative location 2 provides an undesired closer proximity to a known geohazard. A third alternative location of new disturbance for a production facility supporting the 25-5 wells was considered near the existing Duncan facility. While this location would be adjacent to existing infrastructure, Moffett County Road 1, and across from the rancher's cattle operations that has been in existence with truck traffic for decades, it would be nearer to the perennial stream of Slater Creek. Ultimately, it was concluded that there would be fewer impacts to public health, welfare, safety, the environment, and wildlife resources to utilize the existing Duncan facility via existing flow line infrastructure. High priority habitat avoidance is not always possible to develop this federal unit. Topography and sensitive soils are also key issues of this federal unit development. So BMPs are critical to ensuring the least impact. Some key BMPs of note in this OGDP are that PRM will use Group 3 mud and a Tier 4 or equivalent Tier 2 natural gas drilling rig at the 25.5 well pad to minimize emissions near the RBUs. PRM engaged with CPW and Colorado Open Lands in the purchase of a highly protective conservation easement. PRM will utilize existing flow line infrastructure with no permanent production storage at the well pad. And as it relates to construction and soils, the Welba Peak Federal Exploratory Unit is situated within an area with significant topographic limitations for siting of locations. For the proposed location, PRM conducted a geologic hazard assessment. Portions of the assessment maps are shown on this slide. PRM was able to situate the proposed location just outside of areas of concern, while balancing other priorities related to public health, welfare, safety, the environment, and wildlife resources. Of the geohazards evaluated, only 2 were either nearby or present at the location, and both were considered low risk in the assessment. Despite the low risk, the geologic hazard assessment identified several options for BMPs to ensure soil stabilization during construction, setting of conductor, and stormwater monitoring through vegetation stabilization. In consultation with CDPHE, PRM agreed to a more robust stormwater inspection schedule. Another topic that is top of mind is water. This OGDP application proposes disposal of produced water via the approved WPU 14-1 PWD number 1 UIC well, removing trucking impacts. However, at the time of this application submission, the UIC well was pending approval. So staff wanted to see this application presented as if the produced water was hauled away by truck for disposal. The UIC well has since been approved, and it is anticipated to be drilled after wildlife STIPs end this summer. Upon approval of this Welba Peak 1 OGDP, PRM will sundry removal of produced water truck trips from this OGDP. Permanent produced water treatment is not currently permissible due to the area's designation as a disproportionately impacted community. PRM continues to explore options for temporary storage and reuse, as well as making use of the credit system. While not required by rule, PRM has reused produced water in its current operations at its existing well, which is not part of this OGDP. The volumes were small and not enough to move the needle on any charts, but it demonstrates their interest in being protective of water resources and efforts to comply. The next OGDP you see from PRM will include plans for produced water reuse. This OGDP proposes completions activities will occur in the fall or winter after irrigation. PRM has an agreement to purchase water from the rancher who has industrial water rights. A temporary lay flat line will be utilized to eliminate the need for fresh water delivery truck trips during completions phase, saving about 6,200 truck trips per well. Because it is anticipated to take 2 occupations of the WPU 25.5 well pad, and PRM needs until the season after finishing major operations on the last well to complete interim reclamation. In the variance application, PRM requests 27 months from setting conductor on the wells to begin interim reclamation. To complete interim reclamation as required by Rule 1003B would result in a cycle of redisturbance and potential topsoil loss, along with increases in truck traffic. Additionally, these activities would be required to occur during the most sensitive wildlife breeding seasons, which PRM is committed to avoiding. The requested variance would not result in a net increase in impacts. Importantly, PRM consulted with ECMC location assessment and reclamation staff and CPW staff jointly to arrive at this occupation schedule, which relies on the variance application to minimize impacts to public health, the environment, and wildlife resources. With that, I will return the presentation to Mr. Pershala for conclusion.
Thank you, Ms. McKinley. Commissioners, based on PRM's application materials and the presentation, PRM respectfully requests that the Commission find that the application complies with the Energy and Carbon Management Act and satisfies the Commission rules for approval. Find that the proposed operations and BMPs on the WPU 25.5 pad to accommodate 8 horizontal wells satisfies Rule 301A and are protective of and minimize adverse impacts to public health, safety, and welfare, the environment, and wildlife resources. And find that the Rule 1003B variance request satisfies Rule 502C. And based on those findings, we respectfully request that the Commission approve the Wellwood Peak 1 OGDP application, approve the Form 2A for the WPU 25.5 pad, and approve the variance to Rule 1003B. Thank you very much, and we are available for your questions. I think Chair Robbins may be frozen.
That's what it looks like. I'll ask a couple questions, but maybe we'll wait for Chair Robbins to see if he'll reappear before we start.
Commissioners, Chair Robbins asked that we take a quick break so that he can re-log in and try and unfreeze. So if we could return at 3.
Okay, welcome back, everybody. Apologies for my internet outages. It's pretty stormy down here in Durango today, and my computer was having difficulty moving from cellular to Wi-Fi and back. But Mr. Pershala, I heard your entire closing statement, so we're good. I think we just need to move to commissioner questions at this point. So questions from commissioners. Commissioner Vesper.
Thanks, Mr. Chair. I wondered if you could talk a little more about the produced water reuse and recycling, and I think it's important to highlight the challenges that you're facing associated with that so that it's clear and on the record. My understanding is that the ban of centralized produced water treatment facilities and DICs is what's causing you to be able to develop the infrastructure for reuse and recycling. Is that correct?
Yes, thank you. Thank you for the question, Commissioner. That is correct. PRM is prepared to develop the infrastructure and even install permanent storage, and I think they still need to evaluate whether any sort of treatment would be necessary. And it's my understanding that treatment facilities in particular are what is specifically absolutely prohibited within DICs. So I believe that what they're developing for their next OGDP application is we've found to be falls within the rules, and so we look forward to putting that before you here in hopefully the next 2, if not 3 months.
Okay. Yeah, I think I mean, I understand the challenges associated with the blanket prohibition of centralized produced water treatment facilities in disproportionately impacted communities. I think this highlights the problem with the legislation that directed ECMC to implement those rules. And so just wanted to highlight that this is the result of that, and hopefully we can find a solution to that as we move forward. So I think this is a good example of a missed opportunity for reuse and recycling on the western slope for an application. So thanks for that. I wanted to talk a little bit about trucking. So I think you've heard this from me before, but trucking is the primary impact associated with oil and gas activities on the western slope, at least from a local government perspective. And while I acknowledge that we're seeing some takeaway to the Duncan facility, I think we're still intending on seeing a significant amount of trucking from the Duncan facility to a point unknown, I guess. I'm not sure where it's going. So I wonder if you could talk a little bit about that.
Yes, thank you for the question, Commissioner. And I've thought a lot about this question, given that you and I think, miscommunicated in the last hearing on trucking trips. And we worked to, if I could put a little levity into this, we worked to simplify our truck trips, and unfortunately, they expanded to 4 pages in this application. So our attempt at simplifying them, sometimes you take your job too seriously, but please know that PRM is interested in removing truck trips. And so while we have overwhelmed the application with these 4 pages of information related to truck trips, as mentioned in the presentation, there will be an almost immediate sundry of removal of the produced water truck trips with the what is planned to be the installation of the UIC well and intention to dispose of the produced water. And while PRM cannot make the commitment at this OGDP, they are very intently planning long-term and have made significant plans toward oil pipeline takeaway. And so in the very near future, we intend to also sundry removal of the oil truck trips from this application. So it is PRM's intent that many of these are removed from this application.
Okay, maybe talk a little bit more about like the potential. I understand it's not set in stone yet, but the potential for oil takeaway from the Duncan facility to where, how far is it? What else might it feed? Kind of a broader picture, if you could.
Sure. If you will permit me, I would like to find my notes on that so I can speak as carefully as possible to that. So, PRM has been working for the last 18 months actually on the right-of-way agreements, conducting engineering studies to evaluate size of pipe, boring techniques, topography, route feasibility, conducting on-sites, environmental surveys, developing the future OGDP applications that would contemplate that execution. And as far as distance, I don't believe I can give you an exact distance, but if I were, I know I know two sides of the triangle, so I could maybe.
I don't need to know exact distances, but I mean, more generally, like, it's about 12 miles or it's about 10 miles or it's just over the border in Wyoming or whatever it may be, right?
I wonder if Mr. Shepherd could estimate the possible length that we might be looking at for the oil transfer, future oil
Sure.
transfer.
Yeah, thank you, Joey. What we are looking at planning, the most direct route to answer your question is about 25, 27 miles. It would go diagonal, and you're right, it does then cross right over the border to just south of Baggs, Wyoming, where there is a current Marathon oil pipeline. So that's the most direct route that we're anticipating.
Great. I appreciate you continuing to evaluate that. Do you anticipate that that would be able to have multiple locations feed into it from this exploratory unit?
Yes, Commissioner, if we're going to put that line in, it's our design and plan. It's going to handle the production. We want to put it in once to handle the anticipated production.
Great. Thank you. No further questions.
Other questions of the panel? Commissioner Oath?
Thanks, Mr. Chair. Thanks for your presentation and I think particularly acknowledging kind of some of our significant concerns when we met last fall with some compliance issues and construction occurring before permit application came in. And so I guess just wanted to touch base with you about compliance since that time. So have there been any inspections on the other WPU site or the Duncan site?
Yes, in fact, Fielding Hill staff was in the field conducting its own. We conduct our own inspections on behalf of PRM to try to help stay ahead of corrective actions, if you will. We have our own list of corrective actions to try to make sure that they're addressed before agencies even need to find them. And so we were in the field at the time that ECMC staff arrived, and so we were able to go around the field with the ECMC staff, and it was actually, I think, a very beneficial experience because we were able to learn dialogue and learn through that experience. And so from that, staff identified issues that we were able to say, yes, that's already been ordered, or we saw the same issue and that's already been taken care of. We just, for whatever reason, it's been delayed and here's when it's going to happen. Or we agree with you, we'll get it taken care of. And then we followed up, on the item. So yes, there was a field inspection at both the Duncan facility and then at the 36-1 and then an associated location to the Duncan facility.
Okay, thank you. And I'm glad to hear you characterize it that way. I think we too would look at inspections and compliance as an opportunity to get out ahead of issues, not as a gotcha kind of exercise. It's intended to address issues as early as possible, and to bring facilities into compliance if there are any issues. So appreciate that. And so of the things that were identified, did anything result in any kind of notices of violation that are outstanding? Are there any outstanding issues at any of the sites?
I do not believe so. My colleague, Mr. Cooper, was the one who filed the responses to those field inspections reports, so he can follow up.
Yes, we've worked on all of those corrective actions and in process and have corrected all of those that were identified. There are just a few outstanding that are in process. One is noxious weeds, which is ongoing, and another one with a little site stabilization on one of the facilities that is currently in STIP. We're working with CPW to be able to correct that now. So there's just minor corrective actions left, and all are in process. Everything has been addressed or being addressed at this time.
Okay, thank you. And is there anything that maybe is not continuing to be outstanding, but had come up that you would have characterized? I mean, you said kind of characterize these as kind of minor issues. Is there anything that did come up that you would characterize as maybe a little bit more of a significant issue that needed to be addressed?
I don't think so. I think that what may be most significant is just the noxious weeds and trying to work on that. And we've been regularly monitoring, surveying, and treating those for the last several years, including starting in May of this year. So I think we've seen a big decline. So I think we're making really good headway with that. But that corrective action's been open for probably 18 months now.
Okay, all right.
It's kind of ongoing.
All right, thank you. That's all I had.
Thank you.
Others with questions? All right, we move into deliberations. Feel comfortable with the application? Do we feel comfortable moving it forward? Commissioner Messner.
Thanks. So I appreciate the application. I think significant strides have been taken since previous application that we had. I'm still concerned about truck traffic and will always be concerned about truck traffic with a multiple occupation area, where this is located. Knowing what the county roads and the associated infrastructure is around there, and knowing the history of issues with truck traffic on the western slope and in the Piceance Basin area, that has been a primary driver for complaints for decades now on the western slope, and really started some of the oil and gas wars on the western slope was truck traffic associated with operations. And I think we'll continue to see expanded operations of this type in these exploratory units in this particular area of the western slope. I think taking the necessary steps to develop the infrastructure in order to be able to manage additional development of these areas will be essential to minimize and avoid these historic conflicts that have happened between residents and local governments and oil and gas operators associated with truck traffic. It's a safety issue. It's a quality of life issue on the western slope, but it's a nuisance issue. And so appreciate that there's work that's moving forward on that pipeline. I will believe you that that is the case and hope to see that happen in future applications and be able to see all of this tie together in a more holistic fashion as operations move forward. And also just want to highlight, and I said it already, but this application is a classic example of how there's an unintended consequences that happen with some prescriptive legislation that happened, and the result of that in this particular situation was the inability to reuse and recycle significant amounts of produced water on the western slope. And hopefully that's a situation that could get resolved at some point in the future. But other than that, I do think that this is an approvable application and will be supporting it.
Thank you, Commissioner Messner. Others with the deliberative thoughts? AG Boudreau, do we have special things we need to be thinking about in terms of emotions?
Yes, Mr. Chair, I'd like to recommend a motion that addresses the discrepancies between the 1003B variance request, discrepancies between 28 months, 27 months, and when that calendar starts running. I have some motion language here. That's based on the assumption that you're all moving towards an approval.
Please go ahead and share.
So I recommend a motion approving the application as presented, along with the Rule 1003B variance request to allow the operator a total of 27 months to commence interim reclamation following the setting of conductors for the initial horizontal oil wells to be drilled at the WPU 25-5 well pad. The Form 2A will also include conditions of approval included in the Form 2A attached to the director's recommendation, but with the updates regarding the interim reclamation timeline being 27 months following the setting of conductors for the initial horizontal oil wells as indicated by staff at hearing. So that motion is meant to capture Ms. Waldron's changes that she discussed earlier.
Great. Thank you very much. So moved. Do we have a second?
Second.
Motion second by Commissioner Cross. Further discussion on the motion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? That motion carries. Thank you, Mr. Pashala. Thank you to your client for the presentation. Thank you to staff for the work here. And thanks to everybody for a good, productive day at ECMC, I think. I would move to adjourn. Do we have a second?
Second.
All those in favor signify by saying aye. Aye. Any opposed? We are adjourned. Thank you, folks.
Thank you, Mr. Chair. Thank you, commissioners.